May I please, Your Lordship, on behalf of conducting counsel, Mr. Alakchandra Mohanty. Lordship, the case is that the petitioners are the affected villagers representing the 10 villages surrounded by the plant. Lordship, they are affected. They are due to the operations of the plant. The plant is not adopting the proper environmental measures.
Anyway, your representation is there.
Yes, sir.
How come for 2 years you did not bring it up for hearing, sir? It has not even been listed once. You filed it in 6th June 2020.
Lordship, we have filed but not listed.
I'm asking you, sir. I have been sitting as a Chief Justice in this court for 1.5 years. This matter was never mentioned. A matter filed 2 years ago, not even mentioned for listing. It has come up on its own today.
That the representation is on behalf of the Gramya committee, Milords. And
You see the petitioner's representation. This is the representation of the petitioners, or?
No, Milords, this is the representation by the Ghantiali Gramya committee, which is the village committee, Milords.
That's right.
It is not, Milords, in a... I have to see if they are signatories to. But the village committee is not before my lords.
I know, but they're all villagers.
Yes,
it is seen that the Ghantianali Gramya committee had submitted a representation to the collector.
Yes, my lord.
Yes, ma'am. It's correct.
On 24th February 2020. A direction is issued to the collector. You have not made the company a party.
Your lordship, opposite party 1.
Sorry?
Party 1 is...
Acha. Collector Angul is directed to examine the said representation. And after giving the representatives of the committee, including the present petitioners, notice, as well as opposite party number 1 notice, and after hearing them, and after getting inputs of the State Pollution Control Board, pass a detailed order, not later than 1st November 2022, and to make the order available to the parties not later than 8th November 2020.
My lords, if I may, my lords, Annexure 6, my lords, the collector has in fact directed the sub-collector, my lords, to look into this.
That's okay. Let the collector himself do it.
If it is pending, my lords, the representation.
That's all.
Because it's been more than 2 years now.
That's right. The petition is disposed of. The court clarifies it has not expressed any view in the matter.
Supplementary list item number 2.
Oblige, my lord.
May I please, the lordships? The lordship, this matter relates to rehabilitation assistance scheme, my lord. The application dated 27/6/2014 has been rejected by the opposite party on 22/11/2021, my lord.
My lords, this has to be tagged with the batch of matters which my lords is hearing on the 27th of July because it pertains to the same rules, my lords, 2020 rules.
So, covered matter, your lordship.
27 July.
Yes, my lords, 27 July. I'll give the...
All right, list on 27 July. There are other similar matters. All right.
Supplementary list item number 3.
My lords.
Item number 3.
Why is this before this court?
My lords, item 3. This is an appeal, my lords, against the order.
It's not an appeal.
No, my lords, we have come against the order of the...
But why is it before this court?
Let it come before a single bench.
No, but why is it listed here? Is it a single judge matter?
Yes. Yes, my lords, it is a...
No, the other day Justice Sinha passed an order against the Human Rights Commission
Justice Sinha.
matter. That's a single judge. How does it suddenly become division bench? He's not challenged any virus of statute. List before the roster bench of the single judge. On How come you're coming after a year and 3 months? Anyway.
My lords, we had a review petition
25th,
which was also dismissed.
all right, on 25th July.
Supplemental list for orders, item number 4.
None appears. Discussion about it.
Supplemental list for orders, item number 5.
The matter becomes infructuous, my lord.
Counsel the petitioner states petition has been rendered infructuous. Post of execution.
Supplemental list, item number 6. 6.
Please, your lordship, public interest litigation matter, my lord. On the road, they have constructed and encroached and constructed Latin, my lord. And encroachment in the encroachment case, eviction order has been passed. It was confirmed in appeal, also in revision. Thereafter, remeasurement was done. And even
Anyway,
thereafter, my lord,
representations are that petitioner's representations,
10.
bracket annexure 10 series, shall be examined by the
Tahsildar.
Tahsildar Narsinghpur, and after notice to the petitioners as well as opposite parties, 4 to 14, and after giving them a hearing, a reasoned order shall be passed thereon not later than 10th October 2022. And the order shall be made available to the parties not later than 17th October 2022. The court clarifies it is not expressed in the matter.
Supplemental list, item number 7.
Yes, Mr. Lordship. My lord, this is an PIL application. The petitioner challenged the allotment of 80 acres of the government land.
So many defects, you remove all the defects, sir. The defects we removed within a week, the list thereafter.
Day after tomorrow, my lord.
Supplemental list, item number 8.
None appears. This was not possible.
Supplemental list, item number 9.
By Lordship. Yes, petitioner before Lordship is Lords Acharya Harihar Postgraduate Institute of Cancer, Lords. Lords, petitioner enjoys the exemption, Lords. And Lords, for the amount which is Lords paid to Orissa Medical Corporation, Lords, for procurement of Lords equipments and machinery for treatment of patients, Lords. Lords, the assessing officer says that because you have not furnished, so therefore that amount was added to my income because of on the allegation that not application of income. The 270 penalty was imposed. Your Lordship in the collateral petition has stayed the operation of penalty. Directed not to take coercive action. If your Lordship permit me, only 2-3 documents I want to bring to Lordship's notice. Prior PSI case. Yes, your Lordship may kindly see page 68 for a moment.
No, you're coming here against Annexure 6 order.
Exactly, Milord, because now I have filed appeal, Milords, and now the assistant commissioner says you pay 20%, referring it to a circular, Milords, and Honorable Supreme Court, I am giving copy of your Lordship, Milords, that the circular is not a fetter on the part of the stay granting authority to relax this 20% direction, because it's not a statutory deposit. Only by circular they say pay 20%. Well, your Lordship was very fair in saying that because there is 1 rupee also I cannot because it is meant for me and I live on grant of the central government and state government. Because we don't have any profit with us. So therefore, your Lordship have felt that any amount to be paid below that is at the cost of patient care of the cancer.
In Delhi High Court, they sent it back to the CIT.
Exactly. They sent it back saying that because circular will not be better, you reconsider that for relaxing the condition.
No, let me take instruction in this case.
All right. Notice, Mr. Chimanka accepts notice for the department and seeks time for instructions. Till the next date, no coercive steps be taken against the petitioner. Pursuant to the order at letter dated 7 July 2022. Bracket Annexure 6.
Much obliged.
Just on 19 September.
Minus.
Supplementary list for admission, item number 10.
May please your Lordships.
Pardon to mention, my lord. Item 8, my lord. I was in another court. Matter me adjourned to next week, my lord, to remove the defect. On behalf of Mr. Misra, my lord.
All right. Defects be removed within a week. List thereafter. 8. Yes, Mr. Das.
My lords, this is a writ of 1995. Your Lordship may kindly turn to page 18 of the brief.
Yes.
My lords, page 18 of the brief, the counter by the Tahsildar, your Lordship, see page 14, para 14. Para 14.
Yes.
Now the brief has become very voluminous anyway. Para 14 is said, so far these lands are concerned, the last 5 lines, but the LSC case number was started for acquisition of 20 decimals land from this plot, which was proceeded till the stage of declaration under section 6.1. It was subsequently invalidated. I have given 2 judgments. One is, before your Lordship, 1991 Supreme Court cases 134. Unless and until the lands are notified under and in accordance with section 48, the land acquisition officer has to pass an award in respect of the lands notified. I have already given, Lords, I think I have submitted the judgment. Otherwise, your Lordship may keep it to another date. I have submitted the judgment. So there, the land I have filed a map. It is a landlocked area. They say we have not acquired. It was invalidated. And today the counter, the Tahsildar says, so these lands are notified, but we have not taken possession. We have not. Now the Nilachal Ispat says they are in possession, but it was under the old act. So, Millers, I am entitled to compensation from the date the land has gone from my possession. Now the state is saying this way, that way. They cannot denotify. They have not denotified.
They filed an affidavit of 12th July.
Yes.
Yes, my lord. I have filed an affidavit.
Have you got a copy, sir?
Yes, I have soft copy.
I have got a copy, Millers. Let them say when they have denotified the acquisition, they have proceeded up to 6, and the Honorable Apex Court says they have to pass an award.
No, they seem to have, the company got it mutated in their favor. How did it happen?
Millers, the land, may I say, the land was initially acquired. This is a landlocked land. Landlocked, these small
may I be permitted to submit?
All right, let me, I am on my legs.
Okay, I'm sorry.
Please.
I'm very sorry.
This habit is very bad. This is a landlocked land, Milords. The possession they had taken away. First of all, it was given to one company. That company...
So in the affidavit filed now, the Tahsildar admits, come to para 8.
Yes, Milords. Yes, Milords. He says it is within their boundary.
No, please read on, sir. Please read on.
Yes. It is humbly submitted that the company admitted in this para that have plot number 161 to 161, which corresponds to plot, are within their company boundary. Millers,
no, please read on, sir. There's something in your favor, Mr. Das. I don't know why you're not reading.
Exactly.
Yes.
Exactly.
Which are located in the middle portion of its premises, and company has also admitted they have no reference or any annexures regarding recording of these plots in their favor. But the company had managed to get these plots recorded in their favor through mutation process, although the said plots were not covered in the agreement, nor such properties were ever subject matter of acquisition. Here state is wrong. And no compensation amount has been deposited against these 2 plots by the company at any time.
Just read on, sir.
Yes. Hence, the company has got the land without any valid registered sale deed, so also not acquired the land through LA process, and therefore the company is liable to pay compensation in 2 plots. Not company will pay or the state will pay. We have since 95, I am struggling, Milords.
That is why I am saying, let me kindly allow me to submit what I am saying, whatever I am saying in favor
of who's for the company?
Yes, Mr. Tripathi.
And here, Milords, bang. That
may I be permitted to submit 2 words so far as this case is a year-old case, my lord. The dispute is, the admitted position is that these 2 disputed plots are within the boundary of the company. And It is also admitted that it is not the subject matter of the acquisition, and we have never executed any deed of transfer in favor of the company. We have filed it an agreement as Annexure A. Now the question is, the company is saying that we have paid the compensation. We are saying that we have not received the compensation so far as this. This is a factual dispute. And many times I have discussed with the collector unofficially, many times several meetings are held to resolve this dispute because they are entitled for compensation. Without considering the petitioner's case, I would like to submit that they are entitled for compensation. But who will pay the compensation? Whether the company or because company has not deposited the compensation amount. So may I request or pray your lordship that this matter, your old matter, it can be settled on across the table. Your lordship may direct the District Legal Service Authority to have a meeting with all the representative of all the stakeholders and come to a decision amicably.
There will be another after 95, 2002, another round of legal services.
No, within a time-bound manner, because it needs a settlement.
In law, I am entitled to get it for the state. They had issued 6-1 notification. They have not denotified.
Where the state, only the RO deposit the amount. We are the nodal agency. We are only to pay the compensation amount subject to requisitioning authority deposit the same before the government account.
How would they acquire the land?
No, you are not concerned with that. You are entitled for compensation if your land is otherwise used by the company. But
Anyway,
now
let's hear the company, sir.
Yes.
Yes, my lord. My lord, the total amount has already been deposited.
No, but that disputing,
that is not
sir.
covering these two plots.
That doesn't cover these two plots. They say that para 8.
Yes, my lord. Your lordship may kindly come to my affidavit, my lord, which was filed on 4/3/22 as per your lordship direction, my lord.
Yes.
Lordship got it.
Yes.
4/3/2022, my lord.
Yes.
Annexure B/6, page 9, my lord.
Yes.
This is the notification. May I read, my lord?
Yes.
When it appears to the government of Orissa that land is required to be taken by the government at the public expense for the public purpose in favor of Mrs. Bell Refractories Limited in the village of Gundichapada, district Venkaral, it is hereby notified that for the above purpose, a piece of land measuring no less than 33.
No, these two plots, sir, these two plots are Sabik plot 1434 by 1503 and 1434 by 1507.
Yes, my lord.
It's not included here, sir.
That is admitted, my lord. But that is admitted, that is not included.
Then what's the point in reading this notification?
Yes, ma'am. I'm coming to this, ma'am. So my humble submission before lordship that I have deposited the entire amount for 30.
But not for these two plots, sir.
Yes.
You could not have deposited for these two plots. They were not part of this notification.
That is why subsequent, when my lords, I placed the requisition for 33.15, thereafter it was directed to deposit the entire amount. I deposited the entire amount.
The entire amount is for plots which have been notified, sir.
Yes.
Not plots which are not notified.
Your lordship may kindly see the annexure. Annexure D/6, my lord. Page 13, my lord. The receipt.
Yes.
Receipts are drawn in favor of collector Dhenkanal for rupees 1,59,000 somewhat towards the cost of land in the village of Gundichapada from Messrs. Bell Refractories Limited, my lord. Then, my lord, next page.
Mr. Tripathi, I think you are missing the point. You have paid for land which is included in the notification.
Yes, my lord.
These two plots are not included in the notification. Therefore, no payment has been made as far as these two plots are concerned.
Which was initially included notification.
No. You just now read the notification. These two plots are not there.
But they are
1434 by 1503 and 1434 by 1507. Where are these two there in the notification? You show us.
Your Lordship may kindly see the affidavit filed by the London government advocate, my lords. Their affidavit, which I received the day before yesterday. Paragraph 3 of the affidavit, my lord. The recent affidavit.
You also read para 8, sir, then.
Yes.
Don't stop at para 3. You also read para 8.
Yes, my lord. So should I go through the para 8 first or should I go
Yes,
through para...
yes, you go through para 8 first.
Okay, okay, ma'am. Obliged. That it is humbly submitted that the company admitted in this para that HAL plot number 1612 and 1616, which corresponded to SADC plot number 1434/1503 and 1434/1507 are within the company boundary, which are located in the middle portion of its premises. And the company had also admitted that they have no reference to any annexure regarding recording of these two plots in their table. But the company had managed to get these plots recorded in its favor through mutation process, although the said plots are not covered in the agreement annexure A by 3. Nor such properties were ever the subject matter of the acquisition by the state government. And no compensation amount has been deposited against those two plots by the company at any time. Hence, the company had got the land without any valid registration sale deed and also not acquired the land through land acquisition process, and therefore the company is liable to pay the compensation.
You agree with this, sir?
I do agree with this, my lord. These
then what remains? What remains?
Yes,
so,
my lord.
at the market value of today, you better pay for these two plots, sir.
My lords,
because 24 will section 24 will cover if at all it has been acquired. If it is not acquired, anyway it has to be acquired and handed over to you.
Your lordship,
it can't be that he is left high and dry.
Kindly appreciate one thing, my lord. Your lordship may kindly refer to my last affidavit where the company is already closed. I am not in a position to give the companies. That is the reason.
That is there.
My lord, I have categorically written, if they required, I can ready to return those land, my lords. Categorically written.
Sir, if it is in the middle after so many years, you have enjoyed possession since when? 1994.
My lord, I am not in a position to give my lord. Company is closed, my lords. Company is completely closed, and we took over this company.
No. What closed? What does closed mean?
Not officially. It is not officially liquidated or on 25O of the ID Act, my lord. The company is a completely standstill, my lords. No activity is there, my lords.
No. But what are you doing with the land? What are you doing with the land then?
And moreover, one thing, my lords.
No. 1 minute, sir. What are you doing with the land?
But I am just keeping watch and what 2-3 security guards are there.
No. What does that mean? What does that mean?
May I be permitted to say a few words, my lords? There was, as I understood from the collector, there was a meeting amongst them. And the collector advised them, you give some alternative land to them adjoining the road in lieu of the land which is under your occupation and which is allegedly landlocked, so that the matter can be compromised. Or some more land because you are enjoying the land for last. In that way, you can compromise the case with the, neither they are paying the compensation nor giving any.
No. Are they closed like he claims? Are they closed?
No, closed. It is a Tata company. How can it be closed?
No, my lord, let me clarify one thing.
Nobody can believe that Tata company is closed.
My lord, can I clarify this issue? Initially, Tata was there. Then we referred to BIFR. Then BIFR appointed UCO Bank as operating agency. I took this from the operating agency, my lord. This is no more a Tata company, my lord.
You took it, meaning what? When did you take it?
Yes, my lord.
The agreement is annexed to A by 3.
That is, my lord, from BIFR. Just a moment. Just a moment. My lords, I took over 6/12/2005, my lords. 6 December 2005 from the operating agency, that is UCO Bank.
When you say I, it means Neelachal Refractories Limited.
Nice.
Yes, my lords. Neelachal Limited. That also I have written in my counter, my lords, which was filed on 15/11/2021.
No, where have you said you're closed now? Which affidavit says you're closed and you don't have money and all that?
That is not in writing. That is, I think my learned friend is submitting, but there is no pleading to that effect.
But I am ready to return back the land category of written by paragraph 4 of my last affidavit, my lords. That is 4th March 2022. Paragraph 4, I categorically written because I am not in a position to give the compensation.
No, but how will you physically hand over possession of such 2 plots if it's right in the middle of your factory?
That was also alternative suggestion of the collector. If you want to return this land, then you give a lengthy road to them, wide road to them, so that they can come to this.
Millards, for taking my land since 83, who will pay my compensation? And at this end, as if they are doing a charity, Section 6(1) notification is by the government. So far, this land is concerned, Millards. It is the duty of the government. Government had acquired and handed over.
Government is trying to help the client of Mr. Das. Now he is throwing the blame to government. It's very peculiar.
Kindly read 1997 1 SCC 134. You had issued 6(1) notification. You have never cancelled the 6(1) notification.
That is already lapsed. Award has not been passed. They have not deposited the amount.
You are bound to pass. The law is you are bound to pass. Now I am under 24(2). I am entitled under the new act.
No, but what was the date of the 6(1), sir?
Your Lordship, I kindly see. They have admitted in their counter affidavit, page 18. Page 18, they have admitted. Yes, page 18, they have admitted. Paragraph 14, last 5 lines. LSE case number 19 of 79 millards was started for acquisition of 20 decimals of land, plot number 1434 by 1503, which has proceeded till the stage of declaration under section 6(1).
So 6(1) is published on 23/11/83.
Yes, millards.
The acquisition, the award has to be passed within 2 years, I think.
Yes, they did not pass any award.
So then, sir, since 85,
I am entitled to the compensation.
And law mandates that within 2 years award has to be passed, otherwise it is automatically lapsed.
No, but possession they have taken.
Possession. Nobody disputes. Nobody disputes that you are not in possession of your land. It is the company who also admits that I am in possession.
For a second. Your Lordships, I have 1997.
How does he go without any compensation since 83?
That is there. Your Lordship is correct. That is why I am repeatedly submitting before your Lordship. He is entitled for compensation. But only thing is that your Lordship is to give a finding that whether I am liable to pay the compensation because I have not received the compensation amount.
No. See, the point is, as a state, you took over possession because you wanted to acquire it in order to hand it over to the company. That was your plan. So you notified these lands, you took possession. When you took possession, you obviously took possession of these 2 plots also.
My lord, possession is a secondary. First, award has to be passed, then only possession will be secondary.
No, your possession was already taken, he says.
No, possession is with the company because it is a landlocked area. It is
No. How did you, unless you handed over possession to the company can't get possession, sir.
My lord, there is no affidavit so far as handing over possession is concerned.
No. The fact, if you admit that the company is already in possession.
Is also to think that how we will pay the compensation amount without recovering. Then your Lordship may say we will recover it from the.
Do that.
Yes, that your Lordship may direct. Yes, we will recover it from the person who isn't. Then we will pay it to them.
All right.
My lords, one more thing, my lords.
97(1) SEC, please. What is the page number, sir? 97(1) SEC page?
Millards, 97. I had given a copy, Millards. It is, I'm sorry, I'm just pointing out. 97(1) SCC 134. 134. I had given a copy, Millards, already.
My lords, I have got one more submission, my lord.
Yes.
My lord, this is although same directing government realizing from me or directing me to give compensation directly to the beneficiary, my lord, almost same. I am not in a position to give money, my lord. So that is the reason clearly I have
Let
written.
the government give the compensation and recover it from you, sir. That's the best part. That's the only way.
My lord,
That's the only way.
Ultimately, my lord, I am the sufferer, my lord. It's very difficult in my part to give, my lord.
Placidum 1 million. My lord.
Sir, your argument is completely untenable. You admit for the last 40 years you're sitting on the land. You admit that man has not got a single rupee.
Yes,
and you're simply throwing up your hand saying, since I have no money, nobody should get any relief, and that's the end of the road.
I'm ready to give the land, my lord.
This is a very strange kind of an argument.
My
so
lord,
after 40 years of enjoying, you quietly say, now you take back the land. And you don't have to pay anything for enjoying the land for 40 years. What kind of an argument is this?
That is the reason, my lord, your lordship may kindly visualize the predicament of my lord.
Whose predicament, sir? This is the whole point. After enjoying the land for 40 years, you now project you are a predicament. You are in predicament. That other man who's lost his land, you have got the sale deed somehow registered in your favor without any authority, and you are playing the victim card now. How is that? Why is the sale deed not being cancelled?
No, there is no sale deed. We have executed an agreement in respect of the plots which we have handed over to it.
Sir, just read your own para 8. He's got a mutation. So you have to cancel the mutation.
You
have to cancel the mutation.
That is also, it is
You
very,
have to cancel the mutation,
I wonder
sir.
how the mutation could be allowed, but they are not getting any records how the mutation could have been allowed in favor of the company without any acquisition.
That is government authority after due, then thereafter it is government authority.
So what you can do is you can have a private sale deed executed by Mr. Das's client in favor of the government, and you pay consideration for it. That's the best. That way it will all be legal. Then you can actually cancel the mutation.
Then the consideration amount we have to recover it from the unless we recover.
That is yes.
That I respectfully beg to submit. That observation has to be recorded in the order. Otherwise, how can we demand it from the company?
No, if the company will get the ownership, then you can recover it. But the company says it does not need the land. You can take away the land. I don't want it at all.
No, my lord, may kindly consider that if we will pay the compensation amount to the
and you take the land. That's it. What you do with the land is up to you, sir.
But that one line at least may be added, your lordship, that this consideration amount which we will pay to the we can go for acquisition even. There is no harm in new act, everything. But the amount is important. That amount has to be deposited by the company. Otherwise, how we can proceed with the we cannot pay it from our own pocket. It will have a very
What? We can have what?
No.
Somebody has lost his
my lord,
possession
because
he
the
invoked
company
the
is
act.
saying that I have no money. Then can it be a ground to exonerate him from the legal liability of making the payment for enjoying the land for 40 years? And we will be settled with the cost of maybe we are not the owner and it is already recorded in their favor. They are in possession. We will pay the amount. That is also my respectful submission. It is not at all justified.
My lord, this is admittedly landlocked land. They had issued 6-1 notification. They did not cancel 6-1 notification.
That is
Possession
lapsed.
Taken over by them, handed over to the other side. And under the Indore Development Act, I am entitled for possession under the new act. Compensation under the new act, my lords.
What my learned senior is saying, that is subject to condition that there is a award is passed. And
when no award is passed, there is a 24-1 talks when no award is passed.
My respectful submission is that 6-1 notification is of the year 1985. And after 2 years, the notification is declared as null and void. We did not proceed with for acquisition and no award is passed.
Because it was never cancelled. That portion plot was never cancelled.
That is by a flux of time, it is lapsed. That is
No.
Because the government state will say
the consequence. Let's see the 1894 Act. What happens if no award is passed under 11?
Section 11 may kindly be seen. I am placing before your lordship. 11A. The collector shall make an award under section 11 within a period of 2 years from the date of publication of the declaration. Declaration is 6.1. And if no award is made within that period, the entire proceedings for the acquisition of the land shall lapse.
Yeah.
Provided that in a case of where the said declaration has been published before the commencement of the so and so, the award shall be made within a period of 2 years from such commencement. So within 2 years, if the award is not passed, that 6.1 notification is lapsed. Admittedly, there is no award. Your Lordship may kindly consider my respectful submission. Yes, there was a 6.1 notification. It is also a fact that it is within the area which is handed over to the company. But fact remains, neither any award is passed, nor the arrow has deposited the amount to us. These are all admitted facts, and my learned friend Mr. Tripathi has acknowledged it. Now he is saying that I am ready to return the land. That is why at the first hearing of this matter, I was praying before your Lordship that let there be a settlement. If on the pro rata basis he can, according to the market value of this acquired land,
He says he has no money. That's the whole point.
No. I am not just what I am submitting with after discussing with the collector. If the company will leave, let us say 10 decimal has been landlocked. Against that, the company will leave 100 decimal, which is the market value of 10 decimal as on date.
Mr. Tripathi.
Yes, my lord.
Can you give him equivalent land which is not landlocked from within your premises, adjoining the road?
Not equivalent land, equivalent to the cost of the land, present cost of the land.
Correct. No, present cost will be the same extent then.
Yes, yes, my lord. Yes, my lord. Which is approachable to the petition.
Approachable.
Well, the same portion of land.
That will be the fairest solution, that you give him 2 plots or extent of the 2 plot of land, which is accessible for him, which he can then use.
Adjacent the boundary, my lord. That is I have written, my lord. In my affidavit, I have categorically written that. I am ready to give this land. One is adjacent the boundary. Another is...
Mr. Das, we can ask your client to go there and identify which area of land he wants, and we'll ask him to give you that area of land.
But for this 40
which is
years,
most convenient.
I will not get any compensation, my lords.
No. So for that we can permit you to institute separate proceedings.
My lords, your lordship, in view of the judgments, they were bound to, when they took over possession of my land. It is a landlocked land, my lords. Admittedly, it is landlocked.
Sir, in law, that whole proceedings lapsed in 85, sir, because 83 was the section 6.
Millers, for the other lands, they had given compensation. Millers, if possession is taken, but compensation is not paid, then there would be no lapse, Millers. They are taken away. It is deemed notification.
No, sir.
Section 11.1.
Millers, your lordship may keep it to another date. Also, if it is landlocked, then they are bound to acquire it. It is they admitted now it is
why can't you take land of equivalent extent in a suitable location which is prepared to give you?
Millers, after 40 years of taking over my land, Millers.
No, you're getting land, sir. The value of today's market value of that land is much higher.
No, today's market value is much higher. I don't dispute that. Millers.
And he's prepared to give you that.
Then your lordship may keep it to some other date. Let's take instructions from my client.
All right, let us record these things. An affidavit has been filed on 12th July 2022 by the
Tahsildar
Odapada, Dhenkanal district, where in respect of the 2 plots in question, that is Savik plot numbers 1434 by 1503 and 1434 by 1507, which admittedly belong to the petitioner and are again admittedly have been in possession of opposite party number
6
for over 4 decades now, for nearly 4 decades now. It is stated as under in para 8 and reproduce the whole of para 8. Paragraph. Mr. Tripathi, learned counsel, appearing for opposite party number 6, states that the operations of opposite party number 6 have come to a close and they have no finances to pay compensation for the two plots. Full stop. However, he makes a categorical statement that the opposite party number 6 is prepared to hand over to the petitioner land equivalent of equal extent of an extent equal to the aggregate extent of the two Savik plots, that is numbers 1434 by 1503 and 1434 by 1507, at a location which is accessible to the petitioner. Full stop. He even offers that the petitioner can himself select the extent of land at the site, which can then be handed over to him. Full stop. Mr. Das, senior counsel appearing for the petitioner, seeks time for instructions.
May I pray one thing to us? Your Lordship may record the statement of the company lawyer that these particular two plots are not the subject matter of the acquisition, nor any payment.
He's not disputing all this, sir. In fact, you can
that
add
is
Mr.
not
Tripathi,
disputed,
who does not, while
Lordship
not
may record-
disputing what has been stated in para 8 above.
Yes,
Mr. Tripathi.
that's yes, that's
all right.
My lords, one thing in paragraph 8, my lords, they have written a word that is, but the company had managed to get these plots recorded in its favor.
Yes.
It is not possible to manage, my lords. It's a government authority. After due verification, field verification, they have issued the ROR, my lords.
Sir,
How come I can, my lords,
It is
how
going
can
on.
I can manage this, my lords? It's not an individual land, my lords.
the word manage here is better left undescribed, further undescribed.
Okay, oblige, oblige.
All right. All right.
Deeply oblige, my lords.
List on how many? 4 weeks, Mr. Das?
Similar. Within 4 weeks.
All right. List on 30th August, sir. 30th August.
That is why at the first instance I was requesting, praying your honor, your lordship to send it to the DLSA for this amicable settlement. It is, it has to be, and Mr. Das' client is also affected.
Right, right. All right.
Right.
Supplementary list item number 11.
My lord, I am suffering from high fever. I am unable to guess your lordship put up one.
All right. Mr. Mohanty is unwell.
My lords, I have a request, my lords. I'm appearing for the state. My lords, the state's counter affidavit has not been filed, so I'll need 2 weeks' time, my lords,
All right.
because
Mr. M.K. Mohanty states that he's unwell. Mr. Mohanty appearing, Ishwar Mohanty appearing for the state prays and is granted 2 weeks' time to file the state's counter affidavit. List on
My lord, I am for the liquidator.
20th September. Sir. 20th September.
I am for OP 10.
May not it be earlier, my lord, because that person petitioner is more than 85 years.
I know, sir, but our board is very heavy, so that's the only problem. And there are too many holidays in August. Right.
Great. Supplementary list item number 13.
Well, is over. Mentioned.
May I please your lordship, my lord? My lord, in this petition, this is a public interest litigation, my lord. The petitioner has raised a grievance against the inaction of opposite parties, the authorities, for not taking care and maintaining the public parks and playgrounds of Kotak city. Last time your lordship directed me to file the photocopies by way of affidavit. I have filed it, my lord. My lord, I am for CDA, my lord. I have not received the copy, my lord.
Okay.
I am solving it.
No, your original grievance was about parks.
Parks and playground, my lord.
So now you're confining it to playground in sector 6.
My lord. Also, in my read petition, I have prayed for all the playgrounds of the Cuttack city. Also, the authorities.
No, generally don't say all playgrounds in Cuttack. Then you have to give one proper affidavit. What you've enclosed here is only sector 7.
Yes, my lord.
Sector 6. Sorry.
Yes, my lord.
Sector 6.
Yes, my lord.
In the meantime, my lord, some of the parks have also been transferred to CMC, my lord.
$18,422. No, that's an old affidavit, I think. New affidavit is here. Additional affidavit. This is that. An additional affidavit dated 18th April 2022 has been filed with the petitioner, enclosing photographs of the plot in sector 6 CDA, which was earmarked for a playground. The photographs show a pathetic state of the said area. Counsel appearing for CDA be provided with a copy of the said affidavit today itself. Please give it to him today itself.
I've already shot my.
Okay, a copy has been served on counsel for the CDA, who needs time for instructions. A direction is issued to the CDA to immediately take steps to have the said playground in sector 7 CDA.
My lord, my lord, I think this photograph, my lord, is not updated, my lord. There is some construction work by CDA is going on that on sector 7. That is not a playground, my lord. Actually, in this regard, my lord, Mr. Mahapatra will.
This is not a playground.
No, my lord.
What is it for then?
My lord.
What is in the original plan? What is it earmarked for?
My lord, in this regard, my lord, maybe taken off after recess, my lord, or
after recess. All right, we'll pass it over.
Supplementary list item number 14.
In this case, my lord, state had taken, I'm appearing to the Bishimur, my lord, state had taken time to file counter. Today, my lords, I'm suffering from COVID positive. So I'm feeling uncomfortable to argue the matters. My lords, let it be adjourned to some other day.
This has become more or less infructuous because he has applied for permission in 2016. That permission was rejected on the ground. What I find from the Paraway's comments, on the ground that he could not deposit the royalty amount.
No,
and he says that it is my private land. So even if I extract some sand or I cannot pay. But that is not the law. Even if you from the private land, you have to pay the royalty because all minor minerals belongs to the government. And I think whether this cause of action still survives or not, because it is of the year 2016. In the meanwhile, for a particular work, he wanted to...
No, he wants to extract laterite stone from his own land.
Yes, lateral stone. I'm sorry, not sand.
My lords, your lordships kindly see page 23, my lords, of the writ petition. 23 time was given at the last part, my lords. Time was given for 90 days. And then on the next page, my lords, 90 days on 16/5/2012. Then on the next page, my lords, on 23/6/2012, that is less than within a period of about 45 days, my lords, it is cancelled without giving the 90 days time. This is the first occasion, my lords.
In that event, if he will stick on that Tahsildar's order, then he may prefer appeal before the sub-collector.
There's already an order of the sub-collector. 13/1/2016. There is an order. There's an order of the sub-collector rejecting the prayer.
Yes, my lords. And there also he referred to certain provision, which is not the correct provision for this. My lords, I may read out that provision, my lords. He referred to rule 9, item 9, my lords. Item 9 related to security deposits shall be refunded after expiry of the lease period if the lessee has fulfilled all the condition of lease. And in case of violation of any of the condition of the lease, the security deposit shall be forfeited in the. Here that he was not allowed time to file the deposit, my lords. Your lordship kindly see in two
He was
occasions, my
allowed
lords.
time twice it was
My
extended.
lords, time allowed for 90 days, but before 90 days it was cancelled on one occasion, and that is on page 24, my lords. Then, my lords, your lordship kindly see in another occasion, page 41, my lords. Their time was given 90 days, and it is manipulated to 30 days intentionally that he could not he could not deposit the amount. Just to deprive him to deposit the amount, all the mischief have been played, my lords. And when he approached the sub-collector without referring to the matters, my lord rejected the same.
And another thing, your lordship, in the meanwhile, law is changed. Now, 2016, OMMC rule has been amended. So, under the amended provision, let him approach the.
No, under the amended provision, it says no quarry permit shall be granted to anybody other than state agencies.
Yes.
That is
all project proponents.
My lords, your lordship kindly, there is a provision of proviso, my lords, rule 3 proviso, my lords. Rule 3 proviso, my lords. There it says, provided the extraction, collection, and other removal minor minerals by a person of his own land for normal agricultural operation or other bona fide domestic consumption shall not be constructed on coring operation. So it will not be construed as a coring operation, my lords. Your lordship kindly see the proviso, my lords. Rule 3 proviso.
No, but laterite stone, why do you need it for agricultural purpose or domestic consumption? What is this? I don't understand.
He was
for this undertaking a Monoraga project.
Sorry?
Permitted, my lords. He was digging a pond for the purpose of irrigation, irrigation of his own agricultural land. While digging the pond, he came across a laterite stone for which he could not dig further to get sufficient water for irrigation of his land. For the purpose of irrigation, because of this restriction, he has applied for the permission. Permissions were granted in page 23, my lords. But before completion of that period, intentionally with mischievous mind, so that he will not get that benefit, it was cancelled. Again, my lords, another thing, my second time, again he applied. That was also rejected on the fake grounds. That was manipulated to 90 days, was manipulated to 30
Let
days.
his application again be considered, Mr. Mohanty. Let his application be considered under the present rules.
Yes.
You say the petitioner has questioned two orders in the present petition. One,
let me direct the collector.
Sorry, yes. Question the order dated 13 January 2016, passed by the sub-collector, Sadar Denkanal, rejecting his prayer for permission to extract laterite stone from his own tank in terms of the proviso, first proviso to Rule 3 of the Orissa Minor Mineral Concession Rules 2016 bracket OMMR rules. Bracket. It will be noted here that the ground on which the petitioner's prayer has been rejected is that in terms of para 9 of the OMC bracket amendment bracket rules 2014, open quotation, no quarry permit shall be granted to anybody other than state agencies or project proponents for public purpose, unquote. Notice was issued in the present petition way back on 25th February 2016, and till date no reply has been filed.
My lord, may I kindly record. We have received the Parvai's comment.
Now, it's okay. Last time also you took time.
Yes, my lord.
Till date, no reply has been filed, sir.
Yes.
On the previous date, that is 25th April 2022, The state had sought 2 weeks' time to file a reply. Even today, Mr. Mohanty, learned AGA, only states that he has the parawise comments, but no reply has been filed. Paragraph. It appears to the court that the sub-collector has failed to appreciate the factual context of the matter. In para 4, it is clearly stated that land admeasuring 2.5 acres belonging to the petitioner, situated in Moza Sankwa, Denkanal Sadar, open quotation, could not be utilized properly throughout the year for agricultural purpose due to want of irrigation, unquote, and that for that purpose, the petitioner, open quotation, proposed to dig a firm pond under Mo Pokhari scheme on the said land, unquote. He was even permitted to do so by the block development officer, bracket BDO, Denkanal Sadar. Full stop. Documents to this effect have been enclosed as Annexure 2 series. Full stop. When the petitioner started digging the tank to a depth of 3 meters, he could not reach the water level due to a laterite stone layer. Full stop. It is in this context that on 23rd April 2012, he approached the Tahsildar Denkanal Sadar for permission to extract the laterite stone. Full stop. A report was called from the revenue inspector, who also gave a report, bracket Annexure 4, suggesting that the laterite stone be extracted. Full stop. On that basis, the Tahsildar granted permit in Form O in favor of the petitioner, subject to payment of royalty to the tune of Rs 79,858 for extraction of 800 centimeter of laterite stone. Full stop. This was valid for a period of 90 days. Full stop. According to the petitioner, he received this intimation. No, full stop. However, the petitioner states that he only heard of the above grant of permit when he got a letter dated 23rd June 2012, cancelling the permit on the ground that he could not deposit the government dues within the stipulated period. Full stop. He made 2 representations thereafter. But to no avail. Full stop. Then a grievance is made to the sub-collector, who has, by the impugned order, rejected the petitioner's request. Paragraph. The court finds that Rule 3, the first provisor to Rule 3, bracket 1 of the OMC Rules 2016, clearly states that open quotation, extraction, collection, and or removal of minor minerals by a person from his own land for normal agricultural operations or other bona fide domestic consumption shall not be construed as mining or quarrying operation, unquote. Consequently, since the petitioner is digging the land for a pond for irrigation purposes and not for quarrying any, and not for any quarrying or mining operation. The rejection of his request on the ground that quarrying or mining can be carried on only by the state or state agencies appears not to be correct. Stop. Paragraph. Concept the petitioner states that the petitioner is still interested in digging and pond for irrigation in his own land, and for removal of the laterite stone for that limited purpose, and not as a mining or quarrying operation. Full stop. Paragraph. In view of the above facts, in view of the above discussion, while setting aside the impugned order dated 13th January 2016, Sub-Collector Sadar Denkanal, the court directs the collector.
Controlling authority is the collector.
Directs the collector Denkanal, who is the controlling authority
under the OMMC rules.
In the context of the OMMC rules, to again examine the request of the petitioner.
Yes.
And after giving him a hearing, take a decision on permitting him to remove the laterite stone for the purposes of digging a pond for irrigation purposes. Specifically in the context of the first proviso to Rule 3(1) of the OMC rules. This exercise be completed within a period of 2 months from today.
My lord, the petitioner will appear before the collector.
Yeah. For this purpose, the petitioner will appear before the collector
with the copy of
on 3rd August 2022 or 10th August 2022, along with a downloaded copy of this order. Full stop. The petition is disposed of in the above terms.
Supplementary list item number 15.
Milord, item 15, pardon, Milord. In the meantime, Milord, some new development taken place. So I brought this by way of rapid Lordship while disposing this appeal, Milord. In the meantime, Milord, both Milord, revenue and the appellant respondent has filed the IA for modification of that order under section 154. So that order passed 24/6/2022. I need to file an affidavit to that one. Therefore, Lordship may take up this issue. This issue has already been admitted by the appeal has been admitted by Lordship. So I need time to file.
No, my lords, that's not correct. May I point on this?
Yes.
Was what has happened in this matter is, my lord, there was an original assessment order of 14th March 2014 where various disallowances were made against me. But I appealed to the Commissioner of Income Tax Appeals. The Commissioner first passed the first order, let me call it. He allowed my appeal in toto. He then exercised jurisdiction under section 154 to so-called rectify a few mistakes in his order. By that so-called rectification order, my lords, the CIT appeal actually rejected some of the relief which he had originally granted.
So this was not merely a rectification.
So what happened, Manoj? Then what happened? I approached the tribunal only against the rectification order. The department also, the appeal which they filed only against the rectification order. No order of appeal was filed against the original order. So actually the department's appeal was infructuous because the department got the relief they were seeking in the 154 matter. The tribunal, when he looked at the appeal, the tribunal notes the department has only filed one appeal. And that is against the rectification order, which could not have lied. Their appeal should have been against the original order. Till date, department has not filed any appeal against the original order. While disposing of the appeal, the tribunal notes, and now, my lords, will see the impugned order.
Milord, that is not disputed. I only say, Milord, 26/4, the rectification order again passed by the tribunal. That is part of the order.
I'll explain that also.
So that I bring to you on affidavit to before your lordship so that I can also dispose its matter. That is my
no, you allow appeals of both the SSC as well the department are allowed.
I'll explain. There is an error there. I'm explaining. I'll complete the sequence.
No, that is why, Milord, this order has been passed by tribunal by rejecting the revenue rectification and allowed the respondents. Therefore, I'll hand over to that effect. So I will not. Yes. I have it. Okay. So therefore, I Milord, I file an affidavit. They lordship dispose it up in accordance with law, Milord. I bring to the record before lordship. And I'll prepare on this issue, Lord, because I have no knowledge about this disposal of this order. I've just collected the copy from my friend, Lord.
This rectification that's happened in para 9, that the appeal of the SEC stands allowed and the appeal of the department stands dismissed.
Please, my lord, if my lords now have the impugned order in this appeal, I'll show what has happened. There's a clerical mistake which the tribunal has now corrected. Just see, my lords, para 8 on page 19 of the appeal memo.
Correct.
My lord, it says in the instance case, we find the CIT appeal has passed an order under 154 running into 10 pages, which shows it is not an order passed under rectification for obvious mistake. Therefore, in view of the decision of the Supreme Court in Bolkat, such an order is not maintainable in law. We therefore cancel the rectification order. Now, my lords, the sequitur was that my appeal had to be allowed and the revenue's appeal had to be dismissed.
No, revenue's appeal was also against the same rectification order.
My lords, I'll explain. Their appeal would have to be dismissed because it raised grounds pertaining to the original order of the CIT appeal. It had no grounds assailing the rectification order. Please see the appeal grounds are also reproduced by the tribunal. Kindly see on the first page, Balos, page 15.
No, but then in this order, it notes that the relief sought is only against the rectification order.
Well, if that's the position, there was nothing against the revenue in the rectification order.
Correct.
So the appeal was not maintainable. That's why it had to be dismissed. And that's what the tribunal has now corrected. Now, today as it stands, Malad, let me clear the muddle around, Malad, because there are too many orders.
So today there is one that only the original CITA order which still stands.
Which still stands, not a sale till date. The rectification order is in their favor. There is no appeal against that. They filed an appeal which the tribunal today says dismissed. And Malad, this MA order, if it has to be assailed, it has to be assailed by way of a separate appeal or a writ petition. It can't be assailed in this appeal.
No,
so this appeal has to go.
No, therefore, my lord, I seek, my lord, I pray, my lord, I seek a time to take instruction.
Even this MA order, nothing is wrong in it.
No, I understand. I understand.
In view of all of this,
bow down, your lordship. I understand.
With an application for condemnation of delay, you again challenge the original order of the CITA.
Lord, I understand, Lord, but the fact remains, Lord, this one issue has already been settled by your lordship against the Lord, assessee, Lord, in other case. And Lord, I only take instruction, Lord, whether the.
Well, let me also explain that.
Lord, therefore, I seek some time, Lord. I only seek some time, Lord. I'm just.
For what?
Lord, I take instruction what to, Lord.
No, what is instruction? We'll just note this fact. That's all. No, and you are going to be permitted. I mean, you have your right to do whatever you want in law vis-a-vis this order.
No, that only sought.
We'll only note that we don't have to deal with this order in this appeal.
Absolutely correct. Please, absolutely correct. But that's why I seek 1 week time, Lord.
For
1 week time.
Then don't simply seek adjournment for nothing.
No, but the issue is not issue of the two issues which have been your lordship has already admitted in this case. One is 43B. So far as the electricity 43B.
No, we have not admitted this appeal.
Yes, your lordship has admitted. Your lordship has issued notice and lordship see the order dated.
This appeal?
Yes.
No, never been admitted. So this appeal has not been
No,
admitted.
my lord. This appeal not is not.
Not admitted. That's what I saw. Only notice has been issued.
Yes, notice has been issued. my lord.
Appeal is not admitted, sir. So
Therefore,
deal
my lord,
with
I
it.
see, my lord, I only sought no trial, filed, my lord, your lordship may dispose it.
No. There's nothing. There's nothing in this. The facts are very clear, sir.
Fact is very clear, but the fact remains the order which has been not improving in the first, the order which has challenged annexure 1, not this order, Lord, the revenue was filed this appeal, filed the appeal before the tribunal, arising out of both your, Lord, the order of the first appellate authority.
No, that is now very clear that you did not challenge the original order at all. That's very clear, sir.
Lordship, see the ground. And lordship, see the.
No, there's no prayer.
Copy of the CIG appeal.
See, the first line, these cross appeals are filed by the revenue and SSC against the order dated 7/11/2014.
Please, Malad.
That's it. That's all.
There are no two appeals before the tribunal.
That's
the
right.
Department.
But the appeal is filed by both, my lord, by the revenue and by the SSC, my lord.
Correct. But both of you have challenged only the rectification order.
Actually, they had to challenge only the original order.
Correct.
Rectification order is completely in their favor. Why would they challenge the rectification order? But they challenge the wrong order.
Right. This is a revenues appeal against an order dated 13th October 2017 passed by the Income Tax Appellate Tribunal, which is common to two appeals. One, the appeal by the revenue being ITA number 22/CTK/2015. And the other, the SSC's, the respondent SSC's appeal being ITA number 472/CTK/2014. Both pertaining to assessment year bracket AY 2011-12. Paragraph. The operative portion of the impugned order is to the effect that both the appeals, which were directed against an order dated 7th November 2014 of the Commissioner of Income Tax bracket appeals bracket CIT bracket A, were single quotes allowed. Full stop. Paragraph. The grievance of the revenue as far as the present appeal is concerned is that its appeal was in fact directed against not the order dated 7th November 2014 of the CITA, which was an order by way of rectification, but as the grounds of appeal before the IT-80 would show, the revenue was in fact aggrieved by the original order dated 14th October 2014 of the CITA. Stop. It is for this reason that the questions ought to be urged. Questions sought to be urged in the present appeal
But seven.
What question C is what they really urge. That this was the appeal was against rectification order of 154 read with the original order of CIT.
Yeah. One of the it is with this it is for this reason that the revenue urges before the court that the IT-80 should be asked to rehear the revenue's appeal vis-a-vis the original order dated 14th October 2014 of the CIT bracket A. Paragraph. The background facts are that against a reassessment order dated 14th March 2014, is it a reassessment order or an assessment order? Against an assessment order.
Assessment.
14 March 2014 under section 143 bracket 3 of the Income Tax Act 1961 bracket ITI bracket Act for the aforementioned AY 2011-12. the respondent SSC went in appeal before the CIT bracket A, which appeal came to be allowed by the CIT A by the order dated 14th October 2014. Let's stop. Thereafter, on his own, the CIT-A sought to exercise powers under Section 154 of the Act and purportedly, single quotes, rectified, unquote, the original order dated, the appellate order dated 14th October 2014, thereby passing a rectification order dated 7th November 2014. So this was a 10-page order where, under the purported garb of single quotes rectification, the result was that certain claims of the respondent SSC were in fact disallowed, resulting in affirming parts of the assessment order. So the net result was that the SSC's appeal, which had been entirely allowed by the original order dated 14th October 2014, now only stood partly allowed.
Please, Manoj.
By the rectification order dated 7th November 2014. Paragraph contending that this course of action was impermissible to adopt by the CIT-A under Section 154 of the Act. The SSC assailed the said rectification order dated 7/11/2014 by filing ITA number 472/CTK/2014. Paragraph. It appears that after the SSC had filed the above appeal, the revenue filed a cross appeal being ITA number 22/CTK/2015 against the same order dated 7 November 2014 of the CIT-A. In fact, the revenue could not have been aggrieved by the rectification order since it accepted only part of the claims of the SSC. The revenue was in fact aggrieved by the original order dated 14th October 2014. But for some reason, it chose not to challenge that order dated 14th October 2014, but challenge only the rectification order dated 7 November 2014. Paragraph. In the impugned order, the ITAT noted that the power of the CIT-A under Section 154 of the Act was only to open quotation rectify rectify only obvious and patent mistakes apparent from the record, unquote. And that, as explained by the Supreme Court in T.S. Balaram, Income Tax Officer versus Volkart Brothers and others, 82 ITR 50/SC, even such mistake must be, open quotation, an obvious and patent mistake, and not something which can be established by a long-drawn process of reasoning on points on which there may conceivably be two opinions. Full stop. A decision on a debatable point of law is not a mistake apparent from the record, unquote. Paragraph. It is for this reason that the rectification order dated 7th November 2014 has been set aside by the ITAT by the impugned order. Since both the revenue and the SEC had challenged the said order, the tribunal accepted the plea and allowed both appeals. Paragraph. It appears that
Was both of us filed MNs?
Yeah.
Miscellaneous.
During the pendency of the present, no, that it appears that soon thereafter, both the SSC as well as the revenue filed applications under section 254, right? This is 254.
Well, this is 254 within bracket 2.
Bracket 2 of the Act before the ITAT, pointing out certain obvious errors in the impugned order of the ITAT. Full stop. According to the revenue, the ITAT ought to have examined its appeal as a challenge to the original order dated 14/10/2014 of the CITA and not the rectification order dated 7/11/2014. Full stop. According to the SSC, there was a mistake in allowing the appeal of the revenue, which would not have been maintainable at all in the first place, since the rectification order, which was challenged by the revenue, was not in fact adverse to the revenue. Full stop. The point was that the final line should have been that final operative order of the ITAT ought to have been to allow the appeal of the SSC and dismiss the appeal of the revenue. Paragraph. On both these applications, that is MA number 42/CTK/2017 by the SSC and MA number 11/CTK/2018 by the revenue, a common order has been passed on 24 June 2022 by the ITAT, disposing of the applications and rectifying the operative line of the order dated 13th October 2017, bracket, which is under appeal in the present appeal, bracket, to the effect that the appeal of the SSC was against the order, rectification order dated 7/11/2014 of the CITA was allowed, and the appeal of the revenue against the same order was dismissed. Paragraph. Mr. T.K. Satpathy, learned senior standing counsel for the revenue, urged that he would want to seek instructions on what course of action the revenue should adopt. Now, with the subsequent order dated 24 June 2022 of the ITAT. Full stop. Mr. Sachit Jolly, learned counsel appearing for the SSC, on the other hand, points out that if aggrieved by the order dated 24th June 2022, it would always be open to the department to institute a separate appeal. Full stop. He submits that as far as the present appeal is concerned, since the revenue was intending to challenge the original order of the CITA, which it did not, but only challenged the rectification order dated 7/11/2014, which it could not have come up. There is no merit in the present appeal whatsoever. Paragraph. Having considered the above submissions, it appears to this court that the course of action that the revenue intended to adopt, namely to challenge the original order dated 14th October 2014 of the CIT bracket A before the ITAT, was perhaps inadvertently not adopted by it, since the prayer in the appeal of the revenue before the ITAT was only to set aside the rectification order dated 7th November 2014. Stop. Consequently, the ITAT proceeded as if it was only that order which was under challenge before it. Clearly, the order dated 7/11/2014 of the CITA, in purported exercise of the power under section 154 of the Act, was far beyond the scope of that jurisdiction, which was only to rectify obvious errors. Stop. The order dated 7/11/2014, as pointed out by the ITAT, was a 10-page order, which in fact changed the result of the appeal of the SSC, which had originally been allowed by the CITA by the order dated 14th October 2014. Consequently, the court finds no error having committed by the ITAT in setting aside the rectification order dated 7/11/2014 of the CITA. Stop. Paragraph. As regards the subsequent order passed on 24 June 2022 of the ITAT, if the revenue is aggrieved by such order, it will obviously be open to the revenue to challenge it in accordance with law in separate proceedings.
Please.
Stop. Paragraph. For the aforementioned reasons, the court declines to interfere with the impugned order of the ITAT. The appeal is accordingly dismissed.
I'm so good. My lords, one, I didn't want to disturb. My lords have in the body of the order somewhere recorded the revenue may challenge the order of 24 June 2022 by way of an appeal. It could be an appeal or a writ because my lords, there is a divergence.
Inappropriate proceeding.
Appropriate proceeding. It could be there's a divergence of view in different high courts on whether an appeal lies or a writ lies against a rectification order.
Right.
Grateful.
Right. There was a Coca-Cola order which I think in Delhi High Court we had passed against that.
Was it went to the Supreme Court? Mas 293 ITR, my lords, Justice Kapadia's order.
Correct.
Please, my lords.
What is the scope of the
254 proceedings? In fact, my lords, there the observations were that if there is any prejudice which is caused to any party by an inaction of the tribunal, then that can be rectified, and that doesn't go into the plenary powers of the tribunal per se, but it should be rectified. Those were the observations.
All right.
Grateful, my lords.
All right.
Supplementary list item number 16.
May I please, ma'am? My lord, there are 8 appeals of the same assessee on a singular issue.
Yes.
We may take up the last one, that is 44 of 2020. All are same. All 8 belongs to the same assessee.
Right.
The only question of law framed, there are several, but I'll be pressing for only one. That will be whether the income tax appellate tribunal, Cuttack Bench, Cuttack, is justified in disallowing the depreciation on intangible asset, that is depreciation on leasehold land acquired from government, which can be used for a specific purpose and for a limited period.
So land is subject to depreciation.
Generally, asset only land is an asset which cannot be depreciated.
That's what.
So only appreciated. But in this kind of cases, it is depreciated. Because that is mines. I have to extract gold. Then I have to fill it up and return back to the government.
Correct.
So it's the depletion of that mines on that land. That is why I'm claiming. They are also not allowing me the revenue expenditure because I have paid a premium to take that leasehold land. Under section 37, they are not allowing me revenue expenditure. Neither under section 32, they are allowing me depreciation. And continuously.
Is that case law to support your point?
Yes, there are case laws, and I will be making chat, and I will 100% satisfy my lord on the date of hearing. Let it be admitted all the appeals on only single issue. This is
no. What does the tribunal say on this issue?
The tribunal says same thing. The land cannot be depreciated.
That's right.
But I will satisfy. There are
no. So let us see what is the reasoning of the tribunal.
Oh yes, ma'am.
This is not. There's not even notice has been issued.
Yes, ma'am.
No. Has notice been issued?
No. The first time it came on.
So let's see the order of the tribunal.
Tribunal in the latest order at page number. Page number 121.
Yes.
Para 15. Depreciation on leasehold land. We find that this is covered by the decision of the tribunal in assess his own case. The previous assessment years.
the issue the issue the ground 3.4 for the assessment year 2010-11 and ground of 3.2 for assessment year 11-12 relates to addition made towards charges paid for leasehold land. Ground number 3.2 for the assessment year 12-13, ground number 3.1 for assessment year 13-14. And ground number 3.1 for assessment of 14-15 relates to depreciation on leasehold land. These grounds are interconnected. The assessing officer finds that the assessing company has claimed rupees so and so lakhs under section 37(1) of the Act towards charges against leasehold land for lease period exhausted. Further, the assessee also claimed alternate claim of depreciation under section 32(1)(2), that is depreciation on intangible assets. The assessing officer did not accept the alternate claim of the assessee and made the addition. On appeal, the CIT appeal following the decision dated so and so of the tribunal in assessee's own.
So the only citations there are the IT-80 citations.
Yes.
One is in context of shares, the other is in context of tenancy rights. From Mumbai, both of which say that it cannot be amenable to depreciation.
But I have got decision.
Show us any one.
Just
basically, you're saying a leasehold land taken for mining purposes is amenable to depreciation.
Yes.
So let's see that proposition. Is it supported by any judge?
These are the two tribunal decisions. They have cited some Supreme Court decisions. I could not bring all those decisions. You can tell me, give it, I can give it. In these two decisions, they have allowed. One is Raipur, one is Jaipur. In these two decisions, one is 2017 judgment, one 2019 judgment. They have also cited a Supreme Court judgment inside that. And some other judgments, and they have allowed.
No. Where in the Raipur judgment? Let's see the Raipur judgment. I don't know whether we discussed this at all.
Southeastern coal, one judgment is Southeastern coal.
Correct.
And the other one is, there they have cited a Supreme Court judgment.
No. In Raipur, where is this point that...
that is, I think, in page number 23 or 24.
Let's see that. So the Cuttack bench in East India Minerals versus JCIT.
In fact, the facts are not brought on the record properly. I have narrated that fact. I can read it.
So there is a judgment of the Cuttack bench in East India Minerals Limited versus JCIT. You have that judgment because that is what has been followed by the Raipur bench.
Yes.
To say that it should go back to the assessing officer to again adjudicate.
In fact, in all these office files
given by the coordinate Cuttack bench itself. So this was a remand, and I don't know here. So in this, how come you did not rely on the East India Minerals Cuttack bench?
No, in fact, I have only narrated the fact in this appeal. I was under the impression today it will be admitted, not finally hearing. Otherwise, I would have come with all the judgments and everything, all the details. Otherwise, it may be kept to next week. I will come with everything, and will come ready with everything.
Actually, the associated soapstone is not on depreciation, it's on 35E.
Later on, they have discussed the depreciation part also and allowed.
No, they only talk of 37, 35E.
35, 37, and then depreciation also.
I don't think so.
Because in the Southeastern Coalfield Limited, they have followed the other limestone judgment. And Southeastern towards the end.
Southeastern, they simply send it back to the assessing officer, saying in Southeastern Coalfields, they've simply sent it back to the AO.
Recalculation.
No. For saying you examine the Cuttack bench's judgment in East India Minerals and decide this point again.
Yes, sir. And my facts, if brought on record, and I'll be allowed to argue, I'll be 100% satisfied, this should be allowed.
All right. Counsel for the appellant, SSC, urges this court to consider in the present appeal a single issue concerning allowing depreciation on the leasehold land acquired from the government for mining purposes for a limited period under Section 32 of the Income Tax Act 1961, Bracket Act. Stop. In support of his contention, he places reliance on the judgment of the Cuttack bench of the ITAT in East India Minerals Limited versus JCIT, bracket ITA number 224/CTK/2012, bracket, which according to him has not been taken note of by the ITAT, Sambalpur, in the impugned orders. I think you should examine it.
Yes, ma'am.
Notice, you say Mr. Mahapatra accepts notice for the revenue. Paragraph, the court will be informed on the next date whether the aforementioned decision of the Cuttack bench in East India Minerals Limited, Supra, was challenged before this court, and whether this issue has been decided by any other high court. Stop. List on 27th September. There's no delay in any of the appeals.
No.
I see.
Supplementary list item note 17.
In all the letters, my lord, I am afraid. In all the letters.
Item
May it
17.
please your lordship. With your lordship's kind permission, I beg to just file an affidavit. I have taken time. कौन affidavit? देखा? Here in this writ petition, This is a public interest litigation. My lord, the challenge is to the transfer of two plots which are having Kisam, Gochar and Jhaun. Admittedly, as per the ROR, I have annexed as Annexure 1, page 11, Your Lordship, plot number 1973 towards middle, which is having Kisam, Jhaun, and page 12, plot number 1971 having Kisam, Gochar. Now, this was in fact handed over to the inhabitants of the locality for developing forest in terms of the joint management plan under Annex 2 at page 15. Now, in one of the plots, this Jhaun plantation has been made by the villagers in coordination with the forest department. And the stock is being taken of the plants from time to time. Now, since these steps were taken to alert the land to the DAV school for setting up a school there and damage to the plantation was made, this writ application was filed and Your Lordship subsequently were pleased to pass interim order protecting the land in question. Now, a counter affidavit has been filed by the state, Your Lordship. Therein, Your Lordship will kindly find there are two plots, 1973 and 1971. They say, so far 1971 is concerned, that has not been alienated or transferred, that Your Lordship will find from paragraph 4 of the counter affidavit, page 2, towards the last line, my lord. Now, so far as this 1973 is concerned, they say 5 acres out of 30 acres odd, having Kisam Bogayat in Jhaun. Your Lordship has seen, my lord, the ROR, that is Jhaun, and I have filed the affidavit today also that in 1927 settlement, it was having Kisam Gochar. Now, this has been alienated in favor of IDCO Land Bank. That is what they say in paragraph 4. Now, if at all there has to be an alienation in respect of a Gochar land, then the mandate of section 3 of the OGLS Act is to be followed. Because that has to be first de-reserve. Then after de-reservation, only the allotment question will arise.
No, but this Kisam is Bagayat 3.
Yes.
No, I'll just indicate.
He is referring 1927 record.
My learned friend may kindly bear with me for a moment. Bagayat 3, they have stated in the affidavit. They have not filed any document before Your Lordship regarding this to show that this is Bagayat 3. And there has been a change. That is why the affidavit today, Your Lordship may kindly peruse the affidavit, the annexure I have given at page 4. This is a 1927 settlement wherein the corresponding plot, the Kisam is, Your Lordship will find towards the middle top, Gochara. So therefore, this is Gochara land. So even assuming this, the alienation process in terms of OGLS Act is to be followed, Your Lordship will see the state's affidavit. State's affidavit doesn't indicate any such procedure being followed. And once the alienation procedure is to be followed, then the inhabitants of the locality...
Now, if the ROR now is Bagayat 3 Jhaun.
That is not there. Nothing has been brought on record before Lordship except the statement on affidavit. Now he says that the RI visited the spot and reported that there is no plantation. This report is also not brought before Your Lordship. The counter affidavit is just a bold statement on affidavit without any enclosure justifying such statements. And now he says alienation has been effected. Once alienation has been effected, my friend appearing for the state will agree that the mandate of OGLS Act has to be followed. But this is a land, admittedly, Your Lordship will find, my lord, 27 settlement, it is as Gochara. And once it is Gochar, in terms of section 3, my lord, the alienation process has to, because they have to de-reserve, convert, and then they have to hear the public whether this should be converted or not, my lord. And then, because they have made an enactment as to how the land is to be transferred. So they are bound by the enactment and they have to follow it, my lord.
When did this transfer take place to
There has been nothing such statement in the affidavit. Your Lordship may kindly see the state's affidavit, except saying, Your Lordship may kindly see page 2 of the affidavit, paragraph 4. In reply to the averments made in paragraph 1 of the writ petition, it is humbly submitted that the land officer IDCO Bhubaneswar has filed requisition in form 1A for lease of government land in Mauja so-and-so, that plot number, my lord, which is in dispute, in favor of IDCO Bhubaneswar for creation of land bank, establishment of industries and allied activities. That is what the statute says. Once it is for industries, allied activities, you have to follow the procedure, the de-reservation is to be made, and alienation proceeding is to be done. Your Lordship will find from the entire affidavit that has been filed.
The dates are not indicated.
Nothing indicated, no alienation case, nothing, Your Lordship.
No enclosures. How come there are no annexures to this counter?
Yes, I may be permitted to. So far as this 1973 plot is concerned, my learned friend has submitted vehemently that no document is produced by us so that it is Bogayat Jhaun. Why should we produce? You have not produced that document. Your Lordship may kindly see page 11.
No, 1 minute. His case is it's Gochar.
No, it is not their case. His case is now, today he is introducing.
No, he's filed a rejoinder.
Today, your Lordship may kindly see, it is a 1927 record of right. But the latest...
but you can easily produce a record to show when did you convert it into Gochar.
No, 1927 record of right.
Bhagat, huh?
It is of 2014
so you have to produce a record, Mr. Monty. So if you say it's Kisam Bhagat 3 John.
That is Annexure 1. Your Lordship may kindly have a glance, page 11. My Lord may kindly have a glance. The tick mark is there, middle section, 1973, Bogayat 3 Jhaun. It is the latest record of right of consultation. That is the final and conclusive. My learned friend knows. Once the consultation authority published the record of right, that is final and conclusive so far as the right title interest, so far as the classification of the land is concerned. He is now referring 1927. It's just your Lordship.
Not the latest.
It is the 2014.
What I beg to submit, why I filed this, I took time on the last occasion to indicate that it is land of Gochara nature.
No, originally.
In to 1927.
This is 27 settlement. Subsequently, by virtue of the agreement under Annexure 2, Jhaun plantation was made. Your Lordship, Annexure 2, page 15. This is by the Forest Department. Agreement was executed by the inhabitants of the locality. A committee is being constituted. That is in accordance with the government guidelines. And that therefore, the Kisam has been indicated as Jhaun. So therefore, what I was submitting, once on a Gochar land, Jhaun forest has been done, the mandate of section 3, your Lordship will see, 3 says, once there is a land of this nature, the de-reservation in terms of 3A. 3A says de-reservation.
When was it de-reserved? We don't know.
That is what I beg to submit. Unless de-reservation is made, there should be no alienation. So they cannot say, because this is a government land, we just pick up and we will give it.
He is referring at 1927. Your Lordship may kindly see, he is referring at 27, so-called 27 record of right. I don't find where this 11...
Mr. Monty,
yes, ma'am.
You say that there has been a subsequent change.
No, this is not at all related to this plot. What I find just now from plain, your Lordship may kindly have a glance. This is plot number 1161, 1161.
Let me just then explain.
He is referring some other document. He is trying to confuse the matter.
Sorry for the statement. Your Lordship, I'll just demonstrate from record. Your Lordship may kindly come to para 1 of my writ petition itself. Para 1. May I place it, my Lord? Para 1. May I place it, my Lord? I have said plot number 1973 and 1971 corresponds to plot number 1362, 1364 under Khata number 1161. This has not been disputed in the counter affidavit. Now, your Lordship may kindly come to my present affidavit, wherein your Lordship will find, though this is in Goria, I may be pardoned, plot number 1364 and plot number 1362, which I have mentioned in para 1 of my writ petition, is there. And the Kisam is Gochar. And my learned friend saying that I am misleading and confusing, that's not correct.
What I beg to
plot number 1362 and 1364 having Kisam Gochar is very much there in my annexure.
On the date when we transferred the land to IDCO, the Kisam of the land was not Gochar. You Lordship may kindly imagine. He is referring a 1927 record of right.
No, but was it Jhaun?
That is Jhaun. Jhaun is a growth of some tree growth. That is your natural tree growth. Your Lordship knows in Puri Konark Road, there are Jhaun, that is called Jhaun Bana here. That is a natural tree growth of Jhaun tree. And it is, Kisam is Bagayat. And what prejudice is going to be caused to the villagers if, for the sake of argument, I would like to submit, if a DAV school is established there, what prejudice? It is only due to some rivalry between two groups of people. They are filing all these PILs. There is no prejudice. Had it been a Gochara land, as per the present current status of the record of right, then there is every chance for this honorable court to interfere with the matter, how without de-reservation you can transfer the land to IDCO. But as per the current status reflected in Annex 1, which you have relied upon, it is of Bogayat. And if a Bogayat land, and so far as Bogayat land, if at all it will be converted to homestead for the purpose of construction, then all the formalities are bound to be complied by the allotee. That is a very procedure. You have every right to raise objection there even. So all these things are only to create hindrances in developmental work. Some villagers are doing all these things. We are not doing any anti-people activities there. It is for the people. Even if we have given it to the IDCO, 5 acres of land, according to the petitioner, it is going to a DAV public school. They are going to construct a very big starter school there over 5 acres of land. So what prejudice is going to be caused to them?
May I just clarify one thing? My learned senior's submission that they are giving it to the DAV school run contrast to their own affidavit.
No, I am not.
Just 1 minute.
According to you,
My
you have
learned
not
friend is
heard me.
making a
I said
submission.
that according to you, it is going to be given to
allowing me to clarify. My learned senior just now submitted that it is being given to DAV school for a public school, very big school. Your Lordship, may kindly see the affidavit, page 4, paragraph 10.
No, we have
They
not
have said
given.
we are not giving it to DAV school.
We have
so
given
now
it
the
to
question
IDCO.
is whether the transfer in favor of IDCO for a land back could have been effected without following section 3. Because section 3 speaks of 2 things. If it is Gochara,
My lord, it is.
then
We have transferred it
No,
since
that cannot be
2015
piecemeal.
for
Let me
last
just
7
clarify.
years. Now you have not. That is also not impugned in the writ.
There is no alienation proceeding at all. No number, no order, nothing is furnished before your Lordship, my lord, in the affidavit.
That is an internal.
And the state says that we will not furnish anything. We have said that we have done it, that's all.
My lord, may kindly consider this is the government land. You are not the owner. We have transferred it to IDCO, and all this information we will supply to him. Yes, your lordship, I have got all the records of alienation proceeding by the state in favor of the IDCO. That I have indicated in my written counter affidavit.
No, but somehow the dates are not there.
Yes, it is of 2015. Just now I got the instruction. It is 2015.
No.
We have transferred.
And this being a communal land, your
I'm sorry,
Lordship, the public have a right.
2018. It's communal. Again, he is saying that it is a communal land.
Yes.
So
Forest growth is a communal land because
these are all,
we have also rights.
These are all contradictory and inconsistent statements which the petitioner is giving time and
I think
again.
you file a supplementary affidavit giving the full facts. Let IDCO also say in what circumstances it gave it to the DAV. Because IDCO gets it for industrial purpose, correct?
No, allied services, industrial and allied. The school establishment of school is coming under allied service.
Is it?
Yes.
Well, we'll file our reply also. All right. A rejoinder affidavit has been filed by the petitioners in reply to the counter affidavit filed by the Tahsildar Puri. Stating that, enclosing an extract of the revenue record to show that plots 1362 and 1364 under Khata number 1161 in Moza Samanga, which correspond to the consolidated plot number 1971, measuring AC 15.77 decimal, having Kisam Gochar, as well as plot 1973, measuring AC 30.65 decimal, were originally having the Kisam Gochar in 1927 paragraph. Mr. Samir Mishra, learned counsel appearing for the petitioner, states that from the counter affidavit filed by the Tahsildar, although it has been clarified that there has been no alienation of plot number 1971, it does appear that plot 5 acres from out of plot 1973 were alienated in favor of IDCO Bhubaneswar. stop. He submits that the circumstances under which such alienation took place and the further alienation in favor of the DAV school bracket opposite party number 9 bracket has not been indicated.
Will produce the record
Right.
pertaining to that alienation in
Correct.
favor
He
of.
also questions if the procedure required for converting the Kisam from Gochar to Bagayat, as indicated now in Annexure 1, which is a copy of the ROR, in respect of plot 1973, has been followed. Paragraph Mr. D.K. Mohanty, learned additional government advocate, submits that all the relevant records are available with the government. He undertakes to file a supplementary affidavit of the Tahsildar, enclosing all the relevant records, which will go to show the conversion, if any, of the Kisam of plot 1973 from.
No, whether that is required or not, I will explain in my affidavit. What he is saying, because I have not verified
which
this.
will indicate what the Kisam of plot 1973 originally was, and whether it has been changed subsequently to Bagayat. Counsel appearing for IDCO also states that he will file an affidavit explaining the circumstances under which the extent of 5 acres out of plot 1973 has been further given to opposite party number 9, enclosing all the relevant documents in that regard. The affidavits be filed within 4 weeks.
My lord, it may be within 2 weeks. We will file everything because the interim order
Within
is
2 weeks with an advance copy to counsel to the petitioner. Interim order to continue.
Yes. That was passed on contest, Your Lordship. Initially, Your Lordship issued notice. Subsequently, Your Lordship passed the order
So
on.
we'll say the interim order is confined to this 5 acres on plot 1973.
Well, the others, they have not done.
Okay.
But that will do because they have
the
no.
interim order passed by this court on 20th April 2022 is confined to an extent of 5 acres of land in plot number 1973, which is currently with the opposite party number 9.
DAV public, because IDCO has given it according to him.
Right.
Obliged.
My lord is
list on 22nd August.
My lord, it may be preponed because first week of August we'll file all the affidavits.
He should give
There are only 2 days on that third week, 16th and 17th. That's
16th. Obliged.
Let my learned senior also give an advance copy so that I can assist Your Lordship on that, because those documents are.
No, I said
We'll
advance
give,
copy.
we'll give. Don't worry.
Right.
Supplementary list item number 18.
No, I will have to file rejoinder to the counter filed by the
Or
opinion.
rejoinder be filed for the next date. List on 21st September.
Supplementary list item 19.
For item 19, I am appearing, my lord. But here, if your lordship kindly see, the present petitioners, they are the graduates of specialized subject on personal management and industrial relations. Or they are aspirant to join as assistant labor officials, which is the recruitment is to be done as per the 2001 rule. Now it has been 2019 rules, the advertisement has been issued. The advertisement is at page 72, annexure 4. But I am concerned in this matter because the existing rule is 2001 rule. Now 2019 rule has come into force without repealing the previous rule. But there is an express provision in 2001 rule that the persons who are to join as assistant law officer for the recruitment process, they are to have specialized subject degree in labor subjects, my lord. But now the 2019 rule has opened the Pandora box, like they said, all graduates. Then we are, my lord, if your lordship knows, then in different specialized posts in different statutes, they require a specialized subject as labor officer, assistant labor officer, or deputy labor commissioner who has got a specialist subject in his degree merit. So that's the reason why specialized degree courses are being opened. Now, if you also kindly look to the restructuring the assistant level officer at page 58.
Yes.
Page 58, the restructuring done by the government. Annexure 2.
Yes.
So if your lordship looks at second clause, rural level inspector, right side remark, the RLI will be dying cadre, no further recruitment to the post of RLI. Second is assistant level officer, ALO. Right side column, if your lordship looks at, existing RL will be promoted to ALO in due course after relaxation of all the recruitment rules, after which ALO will be the only base level post. Sir, kindly turn to page 72, Bharat. Page 72 is annexure 4, the advertisement I was referring to.
Yes.
This says online applications are invited on prospective candidates through the pro forma applicant to be made available in the website. So and so date is there. For recruitment to the post of service coming under the Orissa Civil Service Group A, Group B, along with scale of pay as mentioned below. The examination will be conducted in accordance with the provision of Orissa Civil Service Combined Competitive Recruitment Examination Rule 1991 as amended from time to time. The relevant portion of the rules are available in the website. The second column is Orissa Labor Services Group B. If your lordship turns to page 75, the educational qualification has been mentioned. Page 75, clause 3 of clause 4, subclause 3. It's a candidate must hold a bachelor's degree from any university.
Mr. Mishra, this advertisement was of January or February?
So it is actually
it's all
10-1, 9-2 is the till 10-1, 22 to 9-9.
No, I know, but now all that dates are over. Did your clients participate or not?
Oh, no, it has not been held. Nobody has been recruited.
No, but there must be a last date for submitting of application.
The examination has not been held.
No, applications.
But applications are filed, but the examination has not been held.
No, but once the advertisement is there and applications have been filed, can you now turn around and say, no, those who are only specialized labor graduates, then only
I have not applied. But I have not applied because my specialist subject is labor subjects.
No, but you're a graduate.
Yes, but I'm a graduate.
Why didn't you apply?
Well, they have not applied. To be honest, Malad, they have not applied. But here's the case, actually, this is contrary to the 2001 rule. If your lordship looks at 2001 rule at page 106, page 106, Malad.
Yes.
This is also government under exercise of Article 309 of the Constitution. The government of Orissa is pleased to make the following rules to regulate the method of recruitment and condition of service of person appointed to the post of assistant labor officer and rural labor inspector. That is now it has been taken out. But if you also kindly turn to page 107, the recruitment. They have specified how many posts to be direct recruitment, what are the posts to be promotional post. The recruitment to the post of assistant labor officer and rural labor inspector shall be made from the following methods, like by direct recruitment to the post of assistant labor officer, rural labor inspector to the extent of 50% through competitive examination by the Orissa Staff Selection Commission. The next page, 108. Page 106, let's do kindly see. 107. it says that by promotion, the extra 50% vacancies arising every year in the rank of assistant level officer who have put in at least 5 years service in the said post on the first day of January of the year to which the selection board meets, having the qualification of degree of Bachelor's Arts, Science, Commerce from a recognized university, degree, diploma from a recognized university or recognized institution in industrial relations and personal management and industrial relation, labor welfare, labor law, management in rural administration with special...
No, so this is only alternative, sir. Just read it carefully.
Yes, ma'am.
Having the qualification of degree in Bachelor of Arts,
Yes.
Science, Commerce from a recognized university, and degree diploma from a recognized university.
Yes, and degree diploma from a recognized university or recognized institution in industrial level so and so. By promotion to the extent of 50% of the vacancies rising every year in the rank of rural labor inspector from amongst the suitable employees of Group C service working under the Directorate of Labor Commission. But why I say this, but if you also kindly note, while filling of the promotional vacancy in the rank of rural labor inspector, the preference shall be given to those who have degree and diploma in the recognized universities.
It's only a preference, sir.
Yes, it's a preference, Madam. Absolutely
So
correct.
that way, this is not contrary to that. Here now they've removed this requirement and said ordinary graduate can still compete for this post.
But they have that removal is when this act is subsisting, is still in force. My respective submission is that it's overlapping with each other so far as the recruitment process is concerned. My limited extent of appeal to your lordship is that this rule 4.1a and rule 6.3 of rule 19 overlaps. So either they should have repealed this, they should have made a fresh enactment to that effect, or they should have made a proviso to that extent also. That is the main contention for lordship, my lord. This anomaly.
So what do you say, Mr. Mudali, that you've not made any progress after that advertisement?
No, the last date of submission was February 2022.
And today we're in July. He says nothing has happened.
No.
Nothing has happened, my lord.
It must have proceeded.
No, you find out.
Nothing has happened, my lord.
You can find out. You say the challenge in the present petition is to the requirements is to Rule 6 bracket 3 of the Orissa Labour Service bracket method of recruitment and conditions of service rules 2019, in terms of which the minimum qualification for applying for the post of an assistant labor officer,
yes, madam,
is a graduate, whereas under the Rural Labor Inspectors Service bracket method of recruitment and conditions of service bracket rules 2001, which according to Mr. Mishra and senior counsel for the petitioners is still in force, the requirement was that the candidate should be a candidate for direct recruitment as assistant labor officer should be a graduate having in addition a degree or diploma in the specialized areas of industrial relations, personal management, or labor welfare, public labor law, or management and business administration, or human resources management. Stop. The petitioners, it is pointed out, have not applied pursuant to an advertisement issued on
31/12/2021, page 84.
21/12.
31/12.
On 31st December 2021, with a cutoff date for submission of application forms being 18 February 2022. Stop. Paragraph, Mr. Mudali, learned. You say notice, Mr. Mudali accepts notice on behalf of opposite parties 1 and 2 Notice will issue to the opposite party by 3 by speed post, returnable on the next date. The tracking report will be placed on record. Paragraph Mr. Mudali states that he will file an affidavit within 4 weeks, indicating inter alia whether any further steps were taken pursuant to the advertisement dated 31st December 2021 to recruit assistant labor officers. Full stop. He will also address inter alia. No, apart from giving a parawise reply to the writ petition, he will also address the above issue raised by the petitioners. List on. Meanwhile, OPSC will also file its reply before the next date. September 8th.
Supplemental list for hearing item 20.
Please, Your Lordship. Lords, I am on VC Millers.
Yes, please.
Lords, 20, let us take up 21, which Your Lordship heard in part last week.
Correct.
The appellants in item 20 are present, Milords, virtually. Can their presence be excused, Milords? Because they have to go and cook the Mahaprasad. I am asking them to remove. Your Lordship may see in Janardhan Mahapatra and Vaishnavi Mahapatra, I am asking them to show the videos. I can't show video. Lords, appellant number 2 is there. Name is Vaishnavi.
Right.
And Janardhan, my lords, is switching on the camera.
Yes. All right.
Now, may I pray, my lords, further appearance may be dispensed with, my lords, because I am appearing and I will do the matter. Why should they continue to remain?
No, so appellant number 1 is Janardhan.
Yes, he is there, my lords.
And appellant number 2 is?
Appellant 2 is Bellavali Mahapatra. Both are there.
Okay. Okay. You say appellants 1 and 2 are present in virtual mode. All right. And they need not appear till further orders. All right.
Obliged.
Now we'll continue with
21.
Yes.
Now, my lords, last time as I had placed before your lordship, these are the 2 appellants before your lordship who were facing trial along with 6 others, my lords, before the learned additional sessions judge at Devgarh.
Correct. That 149, I think the point
Yes,
you made. Yeah.
Right, my lords.
Right.
Now, so far as
you say they did not invoke 34, they only invoke 149. Since 3 of the 5 have been acquitted of 302,
my lords,
only 2 of them cannot be convicted of 302 using 149.
Right. Now, basically, your lordship may see the paper book at page number 32, my lords.
Yes.
32, the charge, 5th charge, my lords, I am placing. The court says that you on the aforesaid date, time and place, were a member of an unlawful assembly, the common object of which was to commit the offences of wrongful restraint, voluntarily causing hurt by means of sharp cutting weapon, which offences you knew to be likely to be committed in prosecution of the common object of the said assembly. And that, this is important, some of the members of the said unlawful assembly committed the murder intentionally or knowingly, causing the death of Biramchi Behera. It doesn't say that out of these members of the common assembly, my lords, these 2 appellants committed the murder. And it further says, you being a member of such assembly at the time of committing the that word is illegible, committing committing of that offense, thereby you committed the offense under section 302 IPC, read with section 149 IPC, within cognizance of the Court of Sessions, and I hereby direct that you be tried by the Court of Sessions on the said charges, that is 147, 341 by 149, 323 by 149, 324 by 149, and 302 by 1.
Mr. Panda, there is a section in the CRPC,
my lords,
that mere error in the framing of charge will not.
No, my submission is that this is not an error in the framing of charge.
No.
I will invite your lordships.
464.
Yes. 464, my lords, is not applicable here, and I shall advance my arguments to that effect only. Let us read 464, my lords.
Correct.
Effect of omission to frame or absence of or error in charge. It says, no finding, sentence, or order by a court of competent jurisdiction shall be deemed to be invalid merely on the ground that no charge was framed, or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charges, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact been occasioned thereby. Now, my lords, the meaning of this, my lords, is that had the trial court convicted the appellants under section 302 simpliciter or 302 read with section 34 IPC, this section would have been applicable, my lords, because that would have amounted to an omission to frame a charge under 302 simpliciter or 302 read with 34 IPC, or it would have amounted to an absence of or error in charge. In this trial, my lords, there is no conviction of the appellants under 302 or 302 read with 34. I would not have been able to argue this, my lords, if the conviction would have been either under 302 or under 302 by 34 IPC, or it could have been under 304 Part 2 or 304. That is my submission.
All right.
Now, I will draw your lordship's attention to section 211 of the CRPC. 211, my lords, deals with the contents of the charge. Your lordship may see 211. Every charge under this code shall state the offense with which the accused is charged. If the law which creates the offense gives it any specific name, the offense may be described in the charge by that name only. We are not concerned with 3. 4 says the law and section of the law against which the offense is said to have been committed shall be mentioned in the charge. Here, my lords, at pages 31 and 32 of the paper book, the charges have been stated by the trial court. The offense which has been given a specific name has been described, my lords.
Isn't there a provision which says? Isn't there a provision which says that if in the at the end of the trial the court finds that an offense for some other that some other offense is made out,
my lords,
can the court not convict the person for that offense? There is only if it's a more serious offense, then there could be a failure if there's no charge framed.
My lords, the question is, had the court found that way, my lords, that would have been
No, can an appellate court not find it?
My submission is that now I have not placed the evidence on record. Even when your lordship will go through the evidence and record also, your lordship will find that it cannot be done. I am drawing your lordship's attention to subclause 5 of section 211. The fact that the charge is made is equivalent to a statement that every legal condition required by law to constitute the offense charged was fulfilled in the particular case. So, had there been an alternative charge, my lords, either under section 302 simpliciter or under 302 by 34 IPC, my lords, I would not be having any legs to stand on, and I also would not have wasted your lordship's valuable time by making such arguments, my lords. I know how valuable your lordship's time is, my lords. Then your lordship may see the illustrations there too. Illustration A. A is charged with the murder of B. This is equivalent to a statement that A's act fell within the definition of murder given in section 299 and 300 IPC, that it did not fall within any of the general exceptions of the code, that it did not fall within any of the 5 exceptions to section 300, or that if it did fall within exception 1, one or other of the 3 provisions to that exception applied to it. My submission, my lords, here is, what is the purpose of framing a charge? The purpose of framing a charge is to give the accused notice of the offense for which he stands tried, my lords. That alone is the purpose for which a charge is framed, and there is no other purpose behind the framing of a charge. Otherwise, my lords, as in summons cases, my lords, the substance of the accusations could have also been stated to accused persons, and the accused would have been satisfied with that. Now, if your lordship remembers 56 Supreme Court, Willis-Laney, that is the Constitution Bench decision, my lords. There, my lords, 2 brothers were charged with the offense under section 302 read with 34 of the IPC. One of them was acquitted. The other person challenged his conviction under section 302 before the apex court. The apex court, my lords, after a detailed examination of the principles governing framing of charge, did not hold that to be an illegality, my lords. But it said that where prejudice is caused to an accused, my lords, he can always contend before the court, appellate or revisional, my lords, that he was misled by the charge. Now your lordship may see section 214, CRPC. Words in charge taken in sense of law under which offense is punishable. In every charge, words used in describing an offense shall be deemed to have been used in the sense attached to them respectively by the law under which such offense is punishable. And then, my lords may see section 213. When manner of committing offense must be stated. When the nature of the case is such that the particulars mentioned in section 211 and 212 do not give the accused sufficient notice of the matter with which he is charged, the charge shall also contain such particulars of the matter, of the manner in which the alleged offense was committed, as will be sufficient for that purpose. Lord,
what is the consequence? This 216 also we can read?
Yes, my lords, your lordship may read. Two says, if the 211 section 2 and 6, my lords.
No, section 216.
216. 216 says, court may alter charge.
No, any court.
Yes, I agree, my lords. A court may alter the charge, and it says any court. Your lordship can alter the charge if your lordship wants. But once an alteration of charge is made, my lords, a fresh trial is required to be held.
No, is it? That's the question I was going to ask. Just let's read the consequence.
Yes, my lords. Any court may alter or add to any charge at any time before judgment is pronounced. Every such alteration or addition shall be read and explained to the accused. If the alteration or addition to a charge is such that proceeding immediately with trial is not likely in the opinion of the court to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may, in its discretion, after such alteration or addition has been made, proceed with the trial as if the altered or added charge has been the original charge. So the trial has to be held, my lords.
No. So this word any court means
any
only trial
court means the court trying the offense.
So what can the appellate court do?
My lords, the appellate court first has to appreciate the evidence on record.
No, that's...
My lords, I have not placed the evidence on record. But your lordship is bent upon altering the charge, my lords, and convicting my appellant.
We are bent upon hearing you, Mr. Panda.
Yes, my lords.
We are bent upon only that. We are already.
I am grateful. Let us continue.
And then after hearing you, we'll be bent upon hearing Mr. Mudli.
Yes, my lord.
And then we'll be bent upon doing justice.
My lords. Let us continue after recess.
All right.
ones.
Please, Mark. Now I'll ask your lordship to look at the evidence on record. Before I ask your lordship to look at the evidence on record, I would request your lordship to again recapitulate the prosecution story, which has been narrated in the judgment at page 10, Lords. Your lordship may see paragraph 2 of the judgment at page 10.
Same thing is coming. Okay, you see.
No, it's not the same thing. I'm only.
Oh, no, I'm sorry, sir. I didn't mean to tell you anything. Sorry.
Tenth line from that paragraph, my lords, your lordship may see. I'm not. The prosecution story is that in the same night at about 8:15 p.m., while informant Rabi Behera was returning to his house from the watermelon field, all accused being armed with lathis, tangia and knife, wrongfully restrained him and attacked, for which he shouted for help. Hearing the same, deceased Biran came running, followed by his wife PW2, son Pratap, while PWs 1 and 3 also came running from the watermelon field. On the intervention of deceased Biranchi, Rajkishore dealt an axe blow to him, while Ramani stabbed him by knife, while others assaulted him by lathis. So the prosecution story, my lords, is that am I audible, my lords?
Yes, yes.
And who was the person who was restrained? PW4 was restrained. He called out for help, and the deceased came to his help, followed by the other witnesses, PWs 2, 1, and 3, and one person not examined. The prosecution's further story, my lords, is that after the assault on Biranchi was over, my lords, when PW4 came to the rescue of the deceased, he was assaulted and sustained injuries. This PW4 has been examined by PW7, Dr. Manoranjan Samal, who is the assistant surgeon DHH Devgarh. My lords may look at page 73 what the doctor says.
Yes.
He says on 2/3/2002, I was assistant surgeon attached to district headquarters hospital Devgarh. On that day at 12:15 a.m., my lords may mark the time. On police requisition, I examined Rabi Behera, son of so-and-so, resident of such and such, and found the following injuries. Lacerated wound, size 2 inch into 1/2 inch into 1/3 of an inch on the posterior occipital region. A contusion 3 inch into 2 inch on the right side mid-back position. Injuries were simple in nature, might have been caused by hard and blunt weapon. Age of the injuries were within 6 hours from the time of my examination. Exhibit 6 is my report. 6/1 is my signature. So if the examination of this PW4 was at 12:15 a.m., that is 15 minutes after midnight, my lords, on 2/3/2002 by the doctor, and he has sustained the following injuries. The age of the injuries are within 6 hours from the time of his examination. Incident having happened at 8:15 p.m. Now, what he says in cross-examination is important. The second sentence in the cross-examination. Third sentence. The injuries stated above are not possible by stabbing. Injuries were possible by fall on hard and rough substance. My submission, my lords, is that the prosecution witness himself, my lords, has demolished the story of PW4 having sustained injuries. Because no examination of PW4 on police requisition would have been made at 12:15 a.m. on 2/3/2002, and he categorically says that these injuries are not possible by stabbing. Now, why I say this, my lords, is because of the evidence on record of PW4. PW4 is at page 62 of the brief.
Yes. Yes, please.
My lords may see 8 lines from paragraph 1.
Yes.
It begins in that evening at about 8 p.m.
Yes.
I was coming from the tarbuja field to my house, that is the watermelon field. They stopped me at a distance of 100 cubits from my house. They were armed with pahar, knife and axe. Out of fear, I called deceased Biranchi for help. Biranchi rushed to me. So Biranchi was not there, my lords, when this unlawful assembly assembled, my lords. The unlawful assembly has assembled, my lords, in order for robbery.
Correct.
Immediately, Ekadasya assaulted Biranchi with a pahar. Ekadasya is not convicted under 302, read with 149, or under 302 simpliciter, or 302 by 34 simpliciter. Jagannath,
What is a pahar?
Pahar is a stick, my lords.
Stick.
Jagannath also assaulted with a pahar.
Okay.
No conviction of Jagannath under section 302, my lords.
Right.
Accused Ramani dealt 2 blows with a knife on his chest.
Yes.
Appellant number 2 is alleged to have dealt 2 blows with a knife on the chest of the deceased. Accused Raja assaulted him with an axe on his head. So appellant 1 is stated to have assaulted deceased with an axe on his head. Then he says deceased fell down and accused persons assaulted him indiscriminately with pahar. When I came to the rescue of my brother Biranchi, Benu stabbed on my head with a knife. Kalia and Purna assaulted me with pahar. I have placed the evidence of the doctor, my lords, wherein he categorically says that these injuries are not possible by stabbing. When I called Biranchi for help, hearing my call, Sibba, that is PW1, Belad Sen, PW3, Subhasini, PW2, and Pratap arrived there following Biranchi. We caught hold of him and held him by his arms, and he walked a little distance and fell down. Thereafter, we carried him to his house. We carried him by bus to Khajuri Command, and from Khajuri Command to Devgarh by tractor. We admitted in Devgarh Hospital. He died in the following morning in the hospital. Soon after he left, after his death, I went to Kundhegola to lodge a report. So the substantive statement of this PW4, the informant is that deceased died at Devgarh Hospital on the next day morning. Then your lordship may see paragraph 6.
I snatched away the axe from accused Raja and the knife from accused Ramani and handed over the same to police. Police seized the same on my production. Exhibit 3 is the seizure list. 3/1 is my signature. I was sent to medical for my examination under police requisition. This para 6 is important, my lords, because the weapons of offense, that is the axe and the knife, they were produced by this witness before the IO and it was seized. Now, my lords, I am only placing certain parts of the cross-examination. Page 64, my lords may see, paragraph 10. Except Budhu, all the other 7 accused obstructed me on the way. Soon after their arrival, 7 accused persons had altercation with me. Altercation took place about 5 to 10 minutes. I called aloud when they obstructed me and shouted at me. Sibba, Belarsen, Pratap and Subhasini arrived at the place of occurrence together. Till then, I was not assaulted. Then your lordship may see the next page, paragraph 11. Now, this has to be read in conjunction with his evidence in the chief at paragraph 2. We arrived at Devgarh with the deceased at 12 noon. In para 2, he says that the deceased died in the following morning in the hospital. While coming to Devgarh from our village, Barkot PS and hospital we came across. Pallahoda Hospital and Bamparada Hospital are nearer to my village. We did not lodge report either at Barkot or at Devgarh PS. Para 12, my lords may see the third line. I arrived at Kundhigola PS at 10:30 a.m. We left Devgarh with the body and arrived at our village at 5 to 6 p.m. Para 13, my lords may see the fourth line, the third line. None was there when I handed over the knife to the police. I kept the knife in my room till it was handed over to police. It is not a fact that seized knife and axe belong to him. It should be me, my lords. And that myself and deceased Biranchi assaulted accused Ekadasya with said knife and axe, and he sustained injuries due to our assault. Para 14, your lordship may see. I started from Devgarh to Kundhigola PS and lodged report in a bus at 6 a.m. Lords, these timings are important, my lords, because now your lordship may look at the FIR, which is at page 25 of the paper. At page 25, there is a column, information received at the police station, my lords, in the middle of the page. The date is 2/3/2002. The time is 10 p.m. Now your lordship may look at page 28 of the paper book, the endorsements of the IO. At the end of the plain paper FIR. He writes 10:30 a.m. on 2/3/2002, received the written report for complainant as it revealed a COG case under section 147, 148, 341, 324, 294, 302 by 149 IPC. I treated the same as plain paper FIR.
took up its investigation. After returning to PS, I registered the formal FIR at PS. 10 a.m. on 2/3/2002, he registers PS case number 13, dated 2/3/2002. Now, the FIR was not lodged at Kundhigola PS. As per the informant's version, my lords, on the bus on the way to Kundhigola, my lords, he has scribed the FIR which he has given. So therefore, I am placing emphasis on the timings. Now, as I placed PW4 before your lordship, the evidence of PW4 is that the first assault on the deceased was by the accused Ekadasi, followed by another assault by Jagannath, followed by 2 blows on the chest by appellant number 2, 1 blow on the axe blow on the head by appellant number 1, and thereafter indiscriminate assault by all the appellants after he fell down. Now, your lordship may look at the evidence of PW1. PW1 is at page 49. Paragraph 3 of his deposition.
Yes.
On the same day at about evening, while Rabi, brother of deceased Biranji, was coming to the watermelon field to his house for taking food, all the accused persons obstructed him on the way. Rabi shouted for help and deceased Biranji arrived there. Myself, Belal Sen, wife of deceased and Pratap, also rushed to the spot, that is the village Dandal. Accused Ramani stabbed Biranchi with a knife on his chest. Raja assaulted Biranchi with an axe on his head. Ekadasya assaulted deceased with a lathi. Benu was holding a stick and knife. When Rabi intervened to save his brother, Benu stabbed him with a knife on his head. Joga and Kalia also assaulted deceased Biranchi with lathi. Accused Buddhu came running from his house, saying that he would procure human flesh. This is the evidence of PW1. It is not in consonance with the evidence of PW4.
Oh.
Then, my lords, may look at his cross-examination. Page 51, paragraph 8. 10 lines from the top. The sentence begins after hearing shouts.
Yes.
So he says, after hearing shouts of Biranchi, we rushed from the watermelon field to the place of occurrence and saw the assault. Till our arrival, the assault was not started. Hearing hue and cry of the deceased and the accused, we rushed to the place of occurrence. So he doesn't say that he came on hearing the shouts of Rabi, but he says that on hearing the shouts of deceased, he came. Then, my lords may see, after 3 lines therefrom, the accused were standing 5 feet apart from the deceased. They attacked deceased from the front side. Ramani gave 1 blow with knife. Raja gave 1 blow with the axe. Other accused assaulted with sticks indiscriminately, and I did not count the same. So he also says that there was 1 blow. He corroborates in cross-examination that there was a single blow by appellant 2 with the knife, single blow by appellant 1 with the axe, and indiscriminate assault on the deceased with sticks. Then my lords may look at page 53 of his cross-examination. Paragraph 12. I am the brother-in-law of Rabbi. I used to stay in Charimoncha. We used to keep lathi and axe while watching the field. Your lordship will remember the axe and the knife were handed over by PW4.
Right.
Now, my lords may look at the evidence of PW3. That is at page 58 of the paper book. Paragraph 2. In the night of that day at about 8 p.m., Rabbi was coming from the Tarbuja field to his house to take his meal. On the way, all the accused persons obstructed him. Out of fear, Rabbi shouted for help, calling his brother Biranchi. We also heard his shouts. Myself and Siba came to the place of occurrence. Wife of deceased Biranchi is namely Subhasini, and Pratap also came following the deceased Biranchi. In our presence, Ekadasiya assaulted Biranchi with a pahar. Ramani stabbed him with a knife on his chest. Raja gave a blow on his head with an axe. Jaga assaulted deceased with the lathi. Purna and Kaliya also assaulted deceased with the stick. At that time, Biranchi fell down and Rabbi went to his rescue. When Rabbi was lifting Biranchi, Bennu assaulted Rabbi with a knife on his head. Purna and Kaliya also assaulted with pahar. Biranchi sustained bleeding injuries and fell down. This is the evidence of PW 4, 1 and 3. My submission is that their evidence regarding the assault is not constant, nor is it the same as that of PW between and differs between PW4, 1 and 2. Now in cross-examination, my lords, your lordship may see only at page 61. Three lines I am placing. Accused Raja dealt the axe blow on the front side of deceased Biranchi. First the axe blow was given and thereafter knife blow was given. After receiving the Tangia blow, he was standing. Axe blow and knife blow were simultaneous, one after the other. So what he says in Chief Millards, that the knife blow was first and axe blow was second, in cross-examination he contradicts himself. Now your lordship may see the evidence of PW2. Page 54 of the paper. This is the wife of the deceased. The second line of paragraph 1, my lords may see. Subhasini Behera, wife of late Biranchi Behera, is deposing. About a year back, my husband was coming from watermelon field to my house at about 8 p.m. to take his meal. At that time, all the accused persons surrounded him on the way.
Yes, please.
Rabbi shouted for help. Hearing his shouts, my husband Biranchi rushed to the place of occurrence. Myself and Pratap followed him. Belala and Siba also arrived there. So this lady gives a version that it was the deceased who was coming from the watermelon field to the house, and he was surrounded, and hearing Rabbi's shouts, Biranchi rushed to the place of occurrence, followed by herself, her son, and the other witnesses. How is this consistent, my lords, with the evidence of PWs 4, 1 and 3? I'm sorry, my lords, some difficulty in it. Then at para 2, what she says is this. At that time, Dasi alias Ekadasi gave a blow with a lathi to my husband Biramji. Ramani dealt a blow with a knife on his chest. With a Tanya head. When Robbie went to rescue my husband, Benu stabbed Robbie with a knife on his head. Benu also gave another blow with a lathi on his waist. Purna and Kailasa assaulted my husband with lathis. My husband sustained bleeding injuries and fell down. I helped him and he walked a little distance, again fell down. We carried him in a bus to Khajuri Command, and from village Khajuri Command to Devgarh by tractor. My husband died at Devgarh Hospital. Previously, there was a murder in which some of the accused were murdered. In that case, my husband was a witness for the prosecution. Out of that grudge, they murdered my husband. She introduces a motive which is not spoken of by any of the other accused. Now, from this evidence, my lords, of the 4 eyewitnesses, my lords, what transpires is that the evidence of Robbie that Ramani assaulted twice with a knife is not spoken to by any of the other witnesses nor corroborated by medical evidence. The evidence of all of these witnesses is that there was assault by everybody, my lords, on the deceased. Despite this evidence being on record, the trial judge convicts only the 2 appellants, and that too with the aid of section 149. And it is to be remembered, my lords, that from the evidence of the informant and other witnesses, Biranchi was not surrounded by the accused persons, and the common object of the assembly also therefore could not have been to either restrain or assault or cause injuries or cause the death of Biranchi, the offense for which they stand charged. Now, my lords may see the evidence of PW6 with regard to the injuries at page 70.
Yes.
He says the body was fresh, both eyes closed, etc. We are not concerned. Para 2, he describes the injuries. 1, incised the injury over the skull, size 3 inch into 1/2 inch into 1 inch, starting from lateral end of the left eyebrow, backwards and obliquely, injuring the left parietal bone and lacerated the brain matter with hematoma. The second injury is an incised injury over the right shoulder, injuring the right clavicle bone and right subclavian artery, vertically of size 1 inch into 1.5 inch. 1 inch into 1.5 inch into 1 inch. The third injury, my lords may note, the injury on the chest. A lacerated injury over the first intercostal space, injuring the intercostal artery and vein of size 1 inch into 1/4 inch into 1 inch, horizontally placed anterior aspect of the chest wall. This is the injury which is ascribed to appellant number 2 by the witnesses. When appellant number 2 has stabbed with a knife, my lords, the injury is a laceration
horizontally placed on the anterior aspect of the chest wall. He says all injuries were antemortem in nature. On examination of the scalp, underlying the fracture site of the left parietal bone, membrane was lacerated with fracture site. Brain matter was lacerated with fracture site with hematoma. The rest I need not place. Para 3, my lords, he says, next page, page 71. There are 2 fractures. One fracture of the left parietal bone already described earlier, and second is the right clavicle at the middle portion. Death is homicidal, is due to severe hemorrhage and neurogenic shock, and time since the word death has been omitted is within 48 hours from the time of my examination. The postmortem examination, my lords, was done at about 1 p.m. my lords, on 2/3/2000. Exhibit 5 is my report, 5/1 is my signature. Injuries number 1 is possible by axe. Injury number 2 and 3 are possible by sharp cutting weapons like knife and axe. Lord, how does a laceration be caused by a sharp cutting weapon? I fail to understand. Cross-examination, what he says is, I conducted autopsy on 2/3/2002 at 1 p.m. It took half an hour to me to complete the autopsy. I cannot say if the deceased was treated at Devgarh Hospital soon before his death. Injury 1 and 2 are not possible by sharp stump or stone or any sharp object. Weapon used for injury number 1 and 3 must have sharp cutting edge and heavy weight. In this case, gupti and sword may not be the weapon of offense for causing injuries 1 and 2. Injury 3 has been caused by moderate force. The injuries are possible from the front side or from the lateral side. There are no other injuries on the dead body below the chest. And further he says, I have not examined the weapon of offense in this case. Now, my lords, from the evidence of the postmortem injuries that were found, there is an injury on the scalp, there is an injury on the collarbone, both of which are incised injuries, my lords. The only persons who are alleged to have held sharp cutting weapons are these 2 appellants, my lords. And the third injury, my lords, is a laceration on the anterior aspect of the. So can it be said, my lords, that these witnesses are witnesses to the truth and have deposed with regard to the assault, my lords, truthfully? More so considering the fact that wherefrom were the weapons recovered? They were recovered by Exhibit 3 from the possession of PW4. And admittedly, PW1 also says that they were keeping lathis and axes with them when they were guarding the watermelon fields. Another significant aspect, my lords, is that nothing incriminating has been noted or found from examination of the injuries. They have not been put to any of the witnesses except PW4 after a long gap of time, my lords. At page 67 of the paper book, the PW4 was recalled, my lords. He was examined initially on 17th February 2003. He has been recalled on 22/9/2003, and he has stated I can identify the weapon of offense. MO1 is the tangia, MO2 is the knife, MOs 3, 4, and 5 are the 3 lathis used for the assault of my brother Biraj. In cross-examination, he says, there is no special mark of identification on MOs 1 to 5. But by acquaintance it will be, I could identify. Tangi, knife, and lathis are commonly available in most of the houses. It is not a fact that MOs 1 to 5 belong to me, which I produced before the police. And at the next page, my lords, he has denied the suggestion at the last line, last sentence, 4 lines from the top. It is not a fact that I had not snatched MOs 1 and 2 from the accused, that I did not produce those before the police. Now, this is the evidence on record. And after assessing this evidence, my lords, of the witnesses, what the trial court has found is that it has acquitted all the other co-accused of the charge under section 302 read with 149, convicted all the accused persons, my lords, of the charge under sections 147 and the charge under section 341 read with 149, and has convicted Benu and others, my lords, under sections 324 read with 149 and 323 read with 149 for having caused injuries to PW4, my lords. Now, if these witnesses were actually, my lords, witnesses of truth, I will not go more than that to say against them. Their evidence on record, my lords, would have been corroborated by the medical evidence. But as I placed the medical evidence on record, my lords, the medical evidence does not corroborate either the story of assault on PW4. It also does not corroborate the story of assault made on the deceased also. My further submission before your lordship is this, my lords, that these 2 appellants, my lords, they were singled out and convicted under section 302 read with 149 without any materials being available on record to show that the common object of the unlawful assembly was for some members of that assembly to cause death of Biramji Behra. Now, from the evidence on record and the prosecution story, my lords, what best conclusion can be arrived at is that the common object of the unlawful assembly was to restrain the PW4, and we can drag it to say that he was assaulted, though the medical evidence does not corroborate it. But the common object can be said of the unlawful assembly to be to cause death of the deceased Biramji Behra. And the conviction of these 2 appellants under section 302 read with 149 cannot be sustained, my lords, because of the fact, my lords, that there is no evidence on record to show that apart from the 8 persons who faced trial, there were any other persons, my lords, who were actuated with the common object or were members of the unlawful assembly. Now, if your lordship will look at the judgment, page 12, my lords, the points to be determined were stated, and I had placed those points in extenso before your lordship.
Yes.
Now, the second point which the court framed to be determined is whether accused in prosecution of the common object of such assembly wrongfully restrained informant Robbie and his brother Biranchi. Now, so far as wrongful restraint of Biranchi is concerned, milords, there is no evidence on record except the evidence of PW3. And I must also admit candidly, milords, that paragraph 1 of the evidence of PW2 is either a wrong recording of the evidence or the wrong interpretation of what she has stated. Now, the fourth which he frames for determination, the third point, whether in prosecution of the common object of such assembly hurt was caused to PW4 and to the deceased by inflicting lathi blows. He, as the trial judge himself, milords, eliminates this fact by not convicting the persons whom the witnesses have specifically stated have assaulted with lathis for the charge, milords. And the other aspect that is also to be considered by the appellate court, milords, by your lordships, is that there is no indiscriminate lathi blow injuries found on the postmortem report exhibit 5. The fourth point of determination, whether accused in prosecution of the common object of such assembly inflicted knife and axe blows upon informant Robbie and his brother Biranchi causing injuries. That the court has found that yes, one of the accused, that is Bennu, he inflicted an injury, stab injury on PW4, and the two appellants inflicted an axe blow and a knife blow on the deceased, and they have convictions is under section 323 by 149 against Bennu, 324 by 149 against Bennu, and under 302 dealt with 149 against the appellants. The fifth question is whether Raja and Ramani, in prosecution of the common objects of such assembly, inflicted axe and knife blows on deceased Biranchi with intent to cause his death, which resulted in his death. To that, milords, my submission is that in the charge also it has not been stated so, and it has also been found by the trial judge that they have caused the injuries and for which they have been convicted under sections 302 read with 149, which I say is unsustainable in view of acquittal of the co-accused.
That's it.
Yes.
We'll call on Mr. Mudli.
My lords, I have got some submissions to make on 34 and 149.
Last time you did draw the distinction between common intention, common object. I thought you addressed us on that.
But because of your lordship's queries in the pre-lunch session, my lords, regarding alteration of charge, I think I can argue after Mr. Mudli on that.
No, you have to argue the distinction between common object and common intention.
Yes, my lords.
No, that I thought you argued the other day, last Thursday.
I did.
Ah.
I will only supplement, my lords, give me 5 minutes.
All right, do that, please. Do that.
My lords, there are two vital differences between section 34 and 149.
Yes.
34 declares a rule of criminal liability.
Right.
It doesn't create a distinct offense.
Right.
149 creates a distinct offense. Secondly, my lords, 34 takes into account the fact of participation of every individual offender in the offense. And that is described as a criminal act. It also takes into account the mental state connoted by the word intention. But in 149, my lords, participation of every individual offender is ignored, and also the word the intention is also ignored. So therefore, my lords, this subtle distinction, my lords, is there, that whereas 34 is not a distinct offense, 149 creates a distinct offense, and it must be formed by a member of the unlawful assembly. Now, my lords, for an example, I am saying, let us suppose that there is an unlawful assembly has been constituted, and the unlawful assembly's common object is to commit rioting and murder of members of a particular community, my lords. So, and X is also a member of that unlawful assembly. Now, in course of committing that common object, my lords, the mob comes across a particular individual who is known to X. And X may not have the intention to commit the murder of that particular individual because of some reason or the other. But because he is actuated by the common object, my lords, if the mob commits murder of that individual, my lords, X becomes constructively liable, my lords, because he stands charged under 149, which is not the case, my lords, in case if the charge would have been one under section 34. My submission, my lords, is that there may be cases of overlapping, but this overlapping, my lords, we cannot substitute similar intention with the words common intention. And when your lordship decides to come to a conclusion to alter the conviction, my lords, common intention, my lords, must be there. It can be before the unlawful assembly happened, or at the can be formed at this stage also. But here the evidence on record does not justify, my lords, this court coming to a conclusion that the common intention between appellants 1 and 2 developed at the spur of the moment to cause the death of Biramji. That is again, I say, because of the medical evidence on record.
All right.
Hello. First, dealing with the points for section 149 is concerned.
Yes.
In fact, 8 persons were put to trial, and out of them, 7 have been convicted under section 149 and with other offences. All the accused 7 accused persons who have been convicted under section 149, along with other offences, depending on the roles played by each of the individual accused persons. And it is there in the evidence that all the 7 accused persons formed the unlawful assembly with the common object to harm the deceased. But roles played by each of the individual persons are different. And so for a specific allegation of assault on head, each attributed to the present appellants and present appellant number 1, and to the abdomen to the appellant number 2. May I please, your lords, may kindly turn to section 141. It provides it defines unlawful assembly. An assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons composing the assembly is, the third explanation, to commit any mischief or criminal trespass or other offense. So here there are more than 5 persons assembled at a spot, and their common intention was to
common object.
Yes, common object was to commit the offense. Look, this is the judgment which was placed on last occasion of the Honorable Apex Court, that once other accused persons have been acquitted, so the charge will not be. But that has no application to the facts of the present case. Yes.
If my lords permit, I'll share that judgment on the screen.
No, he's got a copy. He's just given it.
You are saying page to bottom. It may be relevant to note that the charge sheet was filed implicating 20 accused persons who faced trial, and the Lion Trial Court acquitted 17 out of 20 accused persons who faced trial, and 3 accused persons were finally convicted under section 148, 325 by 149, and 323 by 149 IPC. So out of 20, 17 were acquitted, 3 were only convicted. And you will see the next page, page 4. Page 4, first paragraph. Counsel for the appellant submit that the ingredients of section 149 of an unlawful assembly, that this membership must be 5 or more, and in the instant case, out of 20 accused persons who faced trial, 3 have been convicted by the Lion Trial Court under the judgment dated 12/11/2008 under section 148, 325 by 149, and 323 by 149 IPC. And the essential condition of unlawful assembly is that it must be 5 or more persons as contemplated under section 141 IPC. So in that context, since out of 20 accused persons, 17 were acquitted and 3 were only convicted with, it came to less than 5. That is why the Honorable Appellate Court, they are held that they are entitled to acquittal. Well, in the instant case, all the 8 accused persons, all the 7 accused persons have been convicted under section 149 IPC as well as 147 IPC. But so far as other offences are concerned, on the roles played by each of the accused persons, rather the assault made by each of the accused persons, they have been convicted for other offences. But like the present appellants, they have convicted under section 302 IPC and
so that's the point. Just come to page 5, that internal page 5 of that judgment.
Yes. Yes. Roman 5.
No, we have heard after that, the first 2 paragraphs, the legal position.
What judgment? Yes.
The same judgment we were reading.
Yes. We have heard on counsel for the parties, and the legal position in regard to essential ingredients of an offence referred to in section 149 are not in doubt. Section 149 prescribes for vicarious or constructive criminal liability for all members of an unlawful assembly where an offence is committed by any member of such an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object. It may be noted that the essential ingredients of section 149 are that the offence must have been committed by any member of an unlawful assembly, and section 141 makes it clear that it is only where 5 or more persons constituted an assembly that an unlawful assembly is born, provided of course the other requirements of the said section as to the common object of the persons composing that assembly are satisfied. To say in other words, it is an essential condition of an unlawful assembly that its membership must be 5 or more.
So the question Mr. Panda is posing is this.
Yes.
Even you do not dispute that of the 8 persons, only 2 got convicted for 302.
Yes.
And the remaining were not convicted of 302, right?
Yes.
So according to him, if you take 302 as an offense, it amounts to all the others getting acquitted, which is true. Acquitted of 302, which leaves in the fray only 2 people for 302. 2 cannot make an unlawful assembly. So he says you cannot invoke 149 when you convict them for 302 and say 302 read with 149. He says that's an erroneous conviction. There cannot be a conviction for 302 read with 149 when the others of that unlawful assembly are not convicted of that offense.
In fact, all the accused persons have been convicted under section.
No, he says they were not even.
Yes.
Look, he have to read it with the charge. Come to that page 32 of the paper book.
Yes. Page 30, page 31. First charge is that you.
No, fourth charge. Fourthly.
Fifthly, Miller.
Fifthly, sorry,
That
fifthly.
you on
correct.
the aforesaid date, time and place were a member of an unlawful assembly, the common object of which was to commit the offences of wrongful restraint, voluntarily causing hurt by weapon, by means of sharp cutting weapon, which offences you know to be likely to be committed in prosecution of the common object of the said assembly, and that some of the members of the said unlawful assembly
So he
committed the
says he
murder.
did not even specify.
Yes.
This was a general charge for everyone.
Yes.
So prosecution should be presumed not to know which of these 8 people are going to be ultimately convicted for 302. The idea was that all of them get convicted for 302.
Yes.
Read with 149. That is how the prosecution set out with its case. It ends up with a case where 6 of them get acquitted of 302. He says, how can you then sustain a conviction of 302 read with 149 just for 2 of them? Then the question of erroneous charge, he says it doesn't arise because this is the charge.
Yes.
The charge is 302 read with 149 for all of them.
Yes.
He says if you had convicted 2 of them for 302 read with 34 or only 302, then he may not have had a case. Then he says you can then argue that, listen, merely because you're not charged doesn't mean I cannot convict you for 302 read with 34. Because maybe you made a mistake in charge.
Yes.
But you did not convict for 302 with 34, or you did not convict for 302. You convicted for this very charge, 302 read with 149. So the charge is not erroneous, but your conviction is erroneous because there is no 149 vis-a-vis the 302.
Only 2 persons.
Only 2 persons. How can they be 302 read with 149?
May I place only one judgment on our appeal school? This also relates to framing of charge.
This citation may be
2009, volume 16, SEC, page 91. Paragraph 18.
Yes.
Coming to section 218 of the code, the High Court obviously is not justified to say that the charge is defective. Section 463 of the code deals with non-compliance with provisions of section 164. The provisions make it clear that it has to be established that because of the non-compliance an injury has been occasioned to the accused in his defense on merits. Now let's look at 19, last part. Paragraph 19, last part. The above position, this is with reference to section 464 CRPC, the above provision makes it clear that if there is an error or irregularity in the charge which had its relevance on the case, it shall be clear from the bare perusal thereof that no finding by the court of competent jurisdiction shall be deemed to be invalid, merely on the ground that no charge was framed or on the ground of any error in relation to the charge, including any misgender of charge, since in the opinion of...
Correct. This is exactly what he argued. So he says if you had given a conviction under 302 or you had convicted 302 read with 34, then he said, I will not argue because I know 464. I will not argue that without framing a charge for 302 with read with 34, you cannot convict. I will not argue that because I'm aware that under 464, even if you've not framed a charge for that, you can still convict. But here he says you did not. Is there a difference between a case when there is complete acquittal of all offenses like in Mahindra?
Yes.
And a case where members of an unlawful assembly still get convicted for some offense or the other? They're all still an unlawful assembly because they never got acquitted of being an unlawful assembly.
Yes.
They all got convicted for being an unlawful assembly, 149. They only performed different criminal acts. Is a difference between that kind of a case, which is this case, which we have now,
Yes.
and a case where, except 2 members of an unlawful assembly, everybody else gets completely acquitted of all offenses, which is what Mahendra is about. Is there a distinction between these 2 kind of cases?
Lordship, may call this matter next week. In the meantime, I will verify this legal position.
Next
So
week,
I have-
my lord, I am in difficulties on Thursday next week. সেটা করিয়ে লুমা। Week after, my lords, if this comes, it can be done. But before your lordship adjourns it, can I place one judgment of the apex court, which
Yes.
will clarify?
Yes.
That is AIR 1955 Supreme Court, page 274.
Right.
Nanak Chand versus State of Punjab. I am sharing it if your lordship can see. If your lordship permits me to share it on screen.
No, since we are anyway adjourning it.
My lords. Lords, in that case, what has happened is this. I am only saying, explaining. In that case, my lords, several persons were charged under section 302, read with 149 and 148 of the IPC.
Yes.
The trial court, my lords, found 4 persons guilty under section 302, read with 34. And he acquitted the rest, my lords. In appeal to the High Court, my lords, the High Court acquitted 3 persons, my lords. Convicted this appellant before the Supreme Court under section 302 simpliciter, my lords. And he had come to the Supreme Court challenging that conviction. Dear my lords, their lordships say like this. Their lordships say, paragraph 13 I may be permitted to place. It has been argued on behalf of the prosecution that no finding or sentence pronounced shall be deemed invalid merely on the ground that no charge was framed.
Correct.
Reliance was placed on the provisions of section Old Code 535 CRPC.
Right.
Reference was also made to 537. That corresponds to 464 and 467.
Correct.
Section 535 does permit a court of appeal or revision to set aside the finding or sentence if in its opinion non-framing of charge has resulted in failure of justice. Section 537 also permits a court of appeal or revision to set aside a finding or sentence if any error, omission or irregularity in the charge has in fact occasioned a failure of justice. Explanation to the section no doubt directs that the court shall have regard to the fact that the objection could and should have been raised at an earlier stage in the proceedings. In the present case, however, there is no question of any error, omission or irregularity in the charge because no charge under section 302 of the IPC was in fact framed. Paragraph 13, your lordship may see.
All right.
I am sharing it.
All right.
Then their lordship say, in fact, section 232 CRPC permits an appellate court or a court of revision if satisfied that any person convicted of an offence was misled in his defense in the absence of a charge or by an error in the charge to direct a new trial to be had upon a charge framed in whatever manner it thinks fit. In the present case, we are of the opinion that there was an illegality and not an irregularity curable by the provisions of section 535 and 537 CRPC. Assuming, however, for a moment that there was merely an irregularity which was curable, we are satisfied that in the circumstances of the present case, the irregularity is not curable because appellant was misled in his defense by the absence of a charge under section 302 IPC. By framing a charge under section 302 read with 149 IPC against appellant, the court indicated that it was not charging the appellant with the offense of murder and to convict him for murder and sentencing him under 302 IPC was to convict him of an offense with which he has not been charged. In defending himself, appellant was not called upon to meet such a charge, and in his defense, he may well have considered it unnecessary to concentrate on that part of the prosecution case. Attention has been drawn to the medical evidence. With reference to injury 1, the doctor stated that the wounds were not very clean cut. It is further pointed out that the other incised injuries on the head were bone deep. Bone, however, had not been cut. Injuries on the head, although inflicted by blunt weapon, may sometimes assume the characteristics of an incised wound. A reference was made to Glaister on medical jurisprudence, 9th edition at page 241. My lords, even Modi also says the same thing, that injuries on the head may also, in certain circumstances, establish that the wounds were produced by a not inflicted by a blunt weapon. The bone, however, injuries on the head, although inflicted by a blunt weapon, may sometimes assume characteristics of an incised wound. This is also what Modi says. These wounds are usually found over the head bone, which is thinly covered with tissue in regions of the head, forehead, eyebrow, cheek, and lower jaw, among others. It is also pointed that Vasudev PW2 had admitted that Mittu took away the takwa from appellant after Sadhuram had been dragged out of the shop, but no takwa blow was given outside the shop. VW4, another eyewitness, also admitted the same. It was urged that if a specific charge for murder had been framed against appellant, he would have questioned the doctor more closely about the incised injuries on the head of the deceased, as well as the prosecution witnesses. It is difficult to hold in the circumstances of the present case that appellant was not prejudiced by the non-framing of a charge under section 302 IPC. The appeal is accordingly allowed. Conviction and sentence of the appellant is set aside. Case remanded to the Court of Sessions for a retrial. So this answers the query of my lords.
All right. You have one more judgment to look up then.
Milord.
Mr. Mudali has more homework, sir.
My lord, so let him do his homework, Milord. I am also doing the same thing for the last.
All right. So when do you want it, you said, sir?
A week after, Milord.
All right. '28th. All right. At the request of Mr. Mudali, just on 28th.
Supplementary list item 22.
No, what?
20.
20, Milord, I may be excused.
20, yes.
I may be excused from doing it because I have already.
So this will also be 28th.
No, first week of August, Milord. 28th, now 3 matters are there which I have to ask.
This is a 2000 matter, sir.
Yes, Milord. I'll do it in the first week, Thursday. I'll do it.
All right, 4th August.
So 11th, please, Mr. 4th, I may not have Mr.
All right, 11th. He's not free on 4th. All right, 11th.
Yes.
Supplementary list item 22. Item 22. My Lord and Senior, I argue them. In criminal appeal 432, we had given a preliminary note, and this is a one-pager for convenience. We are just giving it. I'll just quickly run through this. Now, the date of occurrence is 13/9/2000. The names of the deceased, we have listed them. The names of the accused persons, along with their criminal appeal numbers, we have given, my lords. Now, my lord may kindly see, so far as serial numbers 5, she was acquitted by the trial court. 6 and 7 are absconding, my lords. I'm told that they are still absconding.
Okay.
Now, charge was under section 302 with 34 and 120B of the IPC. And conviction was only under 302 34, and there was an acquittal under 120B of the IPC. Now, all the appellants were granted bail by this court. They are on bail. Now, if my lord would see, the witnesses who were declared hostile, I have listed them out. 8, 10, 11, 12, and 18. And the main witnesses would be the following 8, my lords. I'll roughly run through this in this order.
Yes.
So if my lord would just see the paper book,
yes,
for the facts of the prosecution case, page 14, the prosecution case has been listed out by the trial court. Paragraph 2. May I just place that?
Yes, please.
The case of the prosecution is that on 13/9/2000 at 5:50 p.m., one Ipari Mohan Rao Patro presented a written report at Surada police station alleging that on the same day at about 10 a.m., his son E. Krishna Rao Patro, hereinafter to be referred to as the deceased number 1, and his villager Ladu Dolabehra, hereinafter to be referred as deceased number 2, went together to village Daringbadi in their Hero Honda motorcycle in connection with their business and collection of money. But on the same day, at about 3 p.m., on hearing about the dead body of his son and dead body of his deceased number 2, lying at Baimela Ghat number 1, 3 kilometers away from village Gajalbadi. By the side of the road, the villager N. Manu Chaudhary and his informant's younger son proceeded to the spot and found the dead bodies of both deceased lying with cut injuries on the head of deceased number 1 and deceased number 2 had sustained multiple injuries, and they ascertained that some unknown culprits had committed the murder of the two persons. On this report, in the absence of OIC, the ASI of police, namely H.K. Naik, who was present at Soroda police station, registered a case under 302/34 of the IPC and took up investigation. On the basis of the FIR, the ASI examined the informant and his associates, intimated his superior officers about the double murder, and left the spot, being accompanied with other police staff for follow-up action. During the spot visit, the ASI H.K. Naik found the dead bodies of deceased number 1 and deceased number 2 at the spot, being identified by the informant and other villagers of so-and-so, and the dead bodies were guarded by the police staff since it was night. In the night at 10 p.m., the OIC of Suroda police station and the Circle Inspector of Police Hinjili, the SDPO Bhanjanagar and the SP Ganjam and the section of police force arrived at the spot. As it was a sensational double murder case, the CI of police Hinjili took charge of the investigation of the case from the ASI on the verbal direction of the SP Ganjam. Now, next portion, my lord, may skip and come to paragraph 3. That is at page 16 of the paper book. The plea of the accused persons would be seen from the statement as recorded under 313 of the CRPC is one of false implication. In other words, the accused persons denied their indictment with the alleged crime. Paragraph 4. To bring home the charges against the accused person, prosecution has examined as many as 26 witnesses. Now, this portion, my lord, may kindly skip and come to paragraph 5, which is at page 18. Paragraph 5, the points for determination in the case are whether the male accused persons had committed the murder of E. Krishnarao Patra and Ladu Dolabehra by intentionally causing the death in furtherance of their common intention. Serial number 2, whether all the accused persons hatched a conspiracy to kill both the deceased persons in pursuance of their agreement and plan in the house of accused Namita Sahu. Now, this second question has been answered by holding that there was an acquittal under 120B. Thereafter, my lords, may kindly see paragraph 7, which is at page 20 of the paper book.
Yes.
Admittedly, the prosecution mainly rests on the circumstantial evidence so as to connect the accused persons with the alleged crime. It is well settled that then they have gone into the principles that my lord may skip and come to page 21, just after those 5 principles. Therefore, at the outset, I advert to the circumstantial evidence as relied upon by the prosecution to prove the guilt of the accused. The first circumstance that both the deceased have met a homicidal death has been proved by the prosecution as discussed above. The next circumstance is that the seizure of gold ring belonging to the deceased E. Krishna Patra pursuant to the statement of accused Pradeep Mahanti, leading to discovery. PW 25, the IO has claimed that in his evidence that the accused Pradeep Mahanti, while in police custody, disclosed before him and the witnesses that he would give recovery of the gold ring of deceased E. Krishna Patra, admitting to have committed the murder of both the deceased along with other accused persons, including absconding accused persons. So this was the second circumstance listed out. And below that, there are also 1 or 2 circumstances which they have listed, that is at paragraph 10, page 26. The next circumstance, para 10 of the impugned judgment. The next circumstance against the accused persons are the seizure of wearing apparels of accused Jairam Behra, wide exhibit 18/2 on his production, and similarly the seizure of wearing apparels of other 2 accused persons, so and so. Then the court goes on to discuss the evidence of PW 21. And ultimately, it results in conviction. Now, before taking, my lords, to further portions of the judgment, my lord may straight away come to the evidence of PW 21. She's a lady, my lords, T. Maheshwari Reddy. As per the prosecution, she is supposed to be an eyewitness. That my lords would find the evidence of PW 21 at page 149 of the paper book. May I just place that, my lords?
Yes.
I'll slowly place PW 21 because this is a major component of the case. On 13/9/2000, I was working as a workman at Konark Sanitary at Lanjipalli, Berhampur. On the said date at 10 a.m., I, along with driver Duryodhan Bisoi. Now, Duryodhan Bisoi is DW1, and 4 other workers of the said factory proceeded to Daringbadi in a van, hired vehicle bearing registration number so-and-so. We proceeded to Daringbadi from Berhampur to Aska, and from Aska to Soroda, and from Soroda to Daringbadi. While we were proceeding in a van and we crossed Soroda, and near Gajalbadi Ghati, I found 6 persons were assaulting 2 persons by means of knife and sword. When I saw the said assault, I told the driver to make the said vehicle slow, and he slowed down the speed of the vehicle. We saw the occurrence from a distance of about 7 to 8 cubits from the road. Seeing the aforesaid occurrence, instead of proceeding towards Daringbadi, we reverted back. Next portions, my lords, are very important. When we reverted back to the vehicle, the vehicle, one of the person from the said 6 accused persons who were assaulting the said 2 persons followed us by a Hero Honda motorcycle. Out vehicle, this probably would be our vehicle. Out vehicle stopped near bridge just before Soroda as the fuel gas was exhausted. The person who was following us by Hero Honda motorcycle reached near our vehicle and stationed the vehicle motorcycle, and he, being armed with a wooden lathi, had given several blows on the windshield glass of the vehicle and destroyed it. Now, my lords, at page 150. In the meantime, 30 to 40 persons have arrived near the said vehicle, and the person who destroyed the windshield of our vehicle told that a vehicle ran over 2 persons and was flying away. Sometimes thereafter, Soroda police arrived near our vehicle and took us to the Soroda PS. At Soroda, the police recorded our statement and left us. Now, this is something which your lordship may kindly keep in mind. I'll come back to this. Now, thereafter, I'll just place paras 2, 3, and 4 below that. The person who, being armed with wooden lathi, destroyed the windshield glass of our vehicle is not there in the accused dock. The witness looked at the accused person standing in the dock and stated that the person who had broke the windshield glass of the vehicle by wooden lathi is not there. I can identify the persons who were assaulting the said 2 persons on the said day of occurrence. Para 3, a TI parade was held in respect of 4 suspects, and I have identified them in the TI parade. The said 4 suspects are 4 male persons, and all of them are present in court today. The witness looked at the 4 male accused persons standing in the dock and stated that she identified the 4 male accused persons before the TI parade magistrate on the date of TI parade. Para 4, it was about 2 to 3 p.m. when I saw the 4 accused persons along with 2 were assaulting the said 2 persons. I saw sitting in the front seat of the said van. I cannot say the name of the persons to whom the said 6 persons were assaulted. Now, at this juncture, my lords may kindly pause and come to the evidence of PW 5. That is at page 110 of the paper book. Dilip Kumar Naik. May I just place para 1 of PW 5, my lords?
Yes.
on 13/9/2000 at 2:30 p.m., I picked up Bhavani Shankar bus at Suroda and went to Daringbadi in the said bus. When the bus reached near the spot and the driver told that something has been happened and accordingly stopped the bus. We, the passengers, got down from the bus and saw the two dead bodies are lying on the road side being murdered. I also found one Hero Honda motorcycle lying at the spot. The driver of the bus told that a car passed through that route towards Suroda, at which I picked up the Hero Honda motorcycle which was lying at the spot and followed the car and found the car was occupied by 3 gents and 3 ladies, including the driver. On our inquiry, the occupants of the car told to have seen a scuffle between the accused persons in one hand and 5 to 6 on the other hand, and out of fear they returned towards Suroda. So I went to the police station taking the car with me. The Hero Honda motorcycle in which I came to the police station was kept in the police station. So here what we find, my lords, is a glaring contradiction with the evidence of PW 21 and PW 5. PW 21 says that this person broke the windshield and he followed them, and he was one of, what is most important is, he was one of the persons who was assaulting the 2 deceased persons. That is absent here. So this is a major...
So that would be a inculpation. No? That would be confession then. If PW5 is going to say, no, I was also assaulting, then he wouldn't be PW5.
Now, PW5, my lords, is one of the prosecution witnesses.
Correct.
He has not been arraigned as an accused.
Exactly. So which is why he will not, from his mouth, he will not get a statement that he was himself assaulting.
Correct. But in view of the evidence of PW 21, that PW5 was the person who followed us and he was the one assaulting, then implication of the 4 appellants becomes doubtful.
No. I think she does not say, only what is asked to her is the person who was chasing you and broke your windshield, is he standing in the dock? And she says no.
No, then my lords may
She's
kindly...
not asked to identify PW5.
No, my lords may kindly relook at that portion.
Yes.
That is at page 149.
Yes.
First paragraph, the relevant portion I placed. When we reverted back to the vehicle, one of the person from the said 6 accused. This, my lord, may kindly take note. When we reverted back the vehicle, one of the person from the said 6 accused persons who were assaulting the said 2 persons followed us by a Hero Honda motorcycle.
The only difficulty is this man's photo is not shown, at least in the court. This PW21 is not asked to identify.
Correct.
Who this person is.
So that's one of the latches of the prosecution, my lords.
No, I don't know how much you can take advantage of this. Anyway.
My lord, I may continue with that. Our vehicle stopped near bridge before Soroda as fuel gas was exhausted. The person who was following us by Hero Honda motorcycle reached near our vehicle and stationed the vehicle motorcycle, and he, being armed with a wooden lathi, had given several blows on the windshield glass of the vehicle and destroyed it. In the meantime, 30 to 40 persons have arrived near the said vehicle, and the person who destroyed the windshield of our vehicle told that our vehicle ran over 2 persons and was flying away.
Anyway,
sometimes thereafter, Soroda police arrived.
The only person who can further explain will be the IO.
My lord, I'll place me in cross-examination also. PW21 has, she can't be believed.
Right.
But this is something which my lords may kindly take note. This para 1. So far as the breaking of the windshield of the Maruti van, may I just show the IO's relevant portion? He has said at page 182 that none of this happened. If my lords want, I'll take my lord straight to that page, page 182.
Yes.
Paragraph 20.
Yes.
I'm just placing that relevant portion of the IO's evidence PW 25. I did not find any mark of violence or damage of the windshield glass or side glass of the said Maruti van during investigation. Now, if I may continue with the cross-examination portion of PW 21. So far as paragraph 1 is concerned, there are two contradictions with the evidence of the IO and the evidence of PW 5. Now, my humble submission is that PW 21 would enjoy the status of a chance witness. So her conduct post the occurrence may also be seen. Here, my lords may see paragraph 8 of her deposition during cross-examination, what she has stated. Paragraph 8. May I place para 8, my lords? Yeah. I did not disclose to the villagers arrived near our van while we were returning from the place of occurrence that 6 persons were assaulting 2 persons by means of knife and sword at a distance of 3 to 4 kilometers from Gajalwadi towards Daringbadi. So first point is she didn't disclose about the double murder to the villagers. Next line is also very important. I also did not disclose the police personnel at the place where our vehicle was stopped due to want of fuel, that I have seen 6 persons were assaulting 2 persons by means of knife and sword at a distance of so and so. So she didn't disclose to the villagers, also to the police personnel.
No, but next line is important.
My lords, when we reached the Sorada police station, it was about evening. When we reached at Sorada police station, I described to the police personnel regarding the fact that 6 persons were assaulting 2 persons by means of knife and sword at a distance of 3 to 4 kilometers from Gajalwadi and the side of the road towards Daringbadi. As far as I remember, Police Babu at Soroda recorded my statement immediately after I reached at Soroda PS and took my signature on that statement sheet. After 39-2000, I was never examined by police. Now, if I may just summarize this, PW 21, according to me, my lords, cannot be believed because of 4 reasons, my lords. First is the evidence of PW 5. Second is the IO's evidence regarding non-breaking of the windshield, PW 25. Third is, my lords, her conduct post-occurrence where she didn't disclose about such an event to the villagers or the police who arrived at the scene. Had she disclosed that the person who were chasing and that, then maybe the actual culprit would have been apprehended. But the fact that the person followed them and he broke the windshield, if that is not disclosed at the spot, then he is also allowed to flee away. So this seems very unnatural, man. A person, somebody follows, he breaks the windshield, the witness doesn't disclose.
What is her cross-examination of the TI parade?
I'm sorry, my lords, cross-examination I couldn't get.
PW 21.
My lords.
About the TI parade.
My lords.
Is there anything come out from that which can help you?
Now, so far as the TI parade, our point of disbelieving the TI parade is that the magistrate PW 7, he says that all the suspects, 4 suspects were there in one go and they were mixed with other accused persons, and then the TI parade was conducted. So far as PW 21 is concerned, she says that there were 2 sets of 2 suspects each. So what the Honorable Supreme Court has said is that you can't have all suspects lined up and have one TI parade. You have to have separate set of TI parades for each individual accused. That is at paragraph 9.
No, but
TI parade she has identified. TI parade she has identified, but that may be an inherently weak piece of evidence because the accused persons, they were all brought about without any face being covered. They were all out in the open.
Is that asked to her when she was cross-examined? That's the point. Was she said, was it suggested to her that she's already been shown these people, or she was already shown their photographs in advance?
That suggestion is there. Suggestion is there, she has denied it. But the IO has said that the faces were all uncovered. But in any case, it's a TI parade of an unknown person whom she has never met. And if my lord would see the further evidence of PW4 and others, this looks to be maybe where these people have been just implicated because it was a sensational case. So, and the trial court also doesn't give, the trial court judgment doesn't consider, I don't know why, but she has not been considered as an eyewitness. I just placed that portion. The trial court somehow proceeds as if it's a case based on circumstantial evidence. So maybe there's a tacit reference that that evidence is not to be taken into account. But if my lords would see other materials, it's a clear case of where these people have been picked up. I'll show those portions. My lord may see PW4, which is at page 109. He was the helper of the bus. Now, may I just place paragraph 1 of PW4, Kanhu 9. On 13/9/2000, I was working as helper in the bus named Escort. That was a line bus going and coming from Suroda to Daringbadi. On that day, I was helper in that bus. 4 to 5 passengers on that day got up into the bus at Manya Kathi Chowk, and they got down from the bus at Ramnabadi Chowk. And after leaving them, our bus went to Daringbadi, and in a return journey from Daringbadi to Suroda, we reached near the aforesaid Ghati at 3 p.m. and we found 2 dead bodies lying by the side of the road. I do not know if any of these accused persons inside the dock had boarded in the bus or got down on that day. I was taken inside the jail to identify the culprits arrested in this case, where this line, my lord may kindly see, where I had identified one of them. Next line is very important. The witness went near the accused persons and replied to have identified none of them. Now, this prosecution witness has not been declared hostile. So, I have got judgments, my lords, 2005 SCC 272, which says that unless you declare such a person as hostile, the prosecution is bound by this. So, this line that I had identified one of them during the TI parade and subsequently when produced in court, he denies, this goes against the prosecution. Had they taken steps to declare this person as hostile, then things would have been different. So if my lord wants, I'll show that judgment right away.
No, I think that's, you can show it, but I don't think there is a issue on that. Yes.
We'll make a compilation of that, but we have got it. If my lord wants, I'll quickly show them also.
What's the motive for this whole crime?
Now, motive, the IO has developed it, saying that it is prior enmity, and also maybe taking away that gold ring and money. But it's all based on the sources of the IO. So there also I have got my lord's own judgment from the Delhi High Court.
No, first of all, these two deceased, are they related?
No, my lord.
Krishna Rao Patru and Ladu Lal Behra? Dala Behra?
No, they are not. They are not related.
And what about the four accused? How are they
They are not interrelated. They are not interrelated.
They're just random four persons.
Random four persons.
They're not friends of each other.
No. What the
Why
evidence?
would four of them get together and?
Yes, I'll explain that. Some of the PWs who have supported the prosecution case, what they have said is that the two absconding accused, they got these four people the day before, and then this murder was planned and it was executed. So they may be the henchmen of the two absconding accused.
No. They're not some armed dacoits. I mean, they're not in dacoity or anything like that.
No.
No, but why would they kill two people like this? For what?
What the IO has found from his sources is business rivalry. If my lord sees the IO's evidence,
whose business? I mean, these four accused have a business.
That's precisely our point, my lords. It's a case of false implication in a sensational case where they probably couldn't find anyone and they picked up these four.
We don't know what the business of the deceased is and what the business of these people are.
The deceased was in the rice business and he was going for this collection of money. The social background of these four, there is nothing.
Because if it is circumstantial evidence, motive becomes important.
And motive, had they got any evidence of motive from the relatives, from the father who have all deposed, then things would have been different. Here the IO, if my lord would see that portion straight away, the IO's evidence, PW 25.
In fact, he was not the IO to start with. He took over the investigation from the earlier IO.
Yes, after one day.
After night.
Yes. My lord, but he was the main IO. My lord may see that at page 168. May I just place paragraph 1, my lords, onwards, just 3 paragraphs.
Yes.
On 39/2000, I was working as the Circle Inspector of Police at Hinjli in the district of Ganjam. On the said date, on receipt of information from ASI SK Naik of Soroda Police Station regarding this case, I left for Soroda and then to the spot. And as per the verbal instruction of SP Ganjam, I took charge of the case from ASI SK Naik and took up investigation of the case. During my part of investigation and as I reached the spot at night, therefore I directed one section of police force and the said ASI to guard the spot, including the dead bodies lying there. 2 dead bodies were lying at the spot. I have re-examined the complainant E. Mohan Rao Patro and other witnesses, namely E. Bijay Kumar Patro, N. Manu Chaudhary, Shankar Dalabehra, and S. Sarat Prusti. Next line, my lord, is important. Thereafter, I contacted my sources and work out clues in this case for its detection. Paragraph 3. It is ascertained from my sources that the accused persons are 6 in number within the age group of 20 to 30 who got down from the bus near the spot at Ramana Badi Chowk, and all of them were wearing full pant and shirts, wearing boot, sandal, etc. Then within bracket, objected to, but the objection is overruled since the police officer is not bound to disclose his source of information. Then the deposition continues. Similarly, I got information that accused persons while decamping from the spot have not used any communication and gone by walk. Then within bracket, objected to, and the objection is to be decided in the judgment. Now, my humble submission is this decision has never been taken in the judgment. I also deployed my staff at various spots to shield the movements of culprit so and so. Thereafter, so it's all on the basis of this that they have said, during my secret inquiry, 2 lines below that, during my secret inquiry, it is revealed that there was business rivalry between deceased E. Krishna Patra with one Kishore Prusti, absconding accused. late Gangadhar of village so and so relating to rice business. At 2:30 am of the said date, I have so and so. So here, my lords, I'll straight away cite that Supreme Court judgment that this information on the basis of sources is very dicey, my lords. 2001 SCC, page 451. Paragraph 18. 2001 3 SCC 451. May I just place paragraph 18, my lords?
18.
1-8.
Right.
The last circumstance which has been used against the appellant is that after the alleged occurrence, he absconded from his house and surrendered in court only for about a month from the date of alleged occurrence. The only evidence on this circumstance is that the investigating officer PW10, who has stated that during the course of investigation, he received secret information to the effect that the appellant was fleeing away wearing only undergarments, and in order to verify the same, he left the police station along with armed forces in search of the accused, went to the house of one Mitesh Jha, husband of the appellant's sister at village so-and-so, where he was informed that Chandra Mohan Mishra, father of the appellant, had gone to the relatives for searching him. This witness has nowhere stated from whom he received the secret information, inasmuch as such information cannot be made a basis to prove this circumstance for being used against the appellant. Now, this was taken note of by my lords while sitting in division bench in the Delhi High Court. And in my lords, in the judgment reported in 2018 SCC Online Delhi, page 10456, this portion was quoted. If I may place that, my lords, that also I have given, my lords, at paragraphs 42 and 43. 10456. My lords may see paragraphs 42 and 43. Under the heading of unconvincing arrests, a circumstance not discussed by the trial court is the arrest of the accused persons themselves. As has become routine in a large number of cases, the move to arrest an accused person always begin with information passed on by inverted comma secret informant. In the present case too, according to PW 19 on 23rd May 2010, when they reached the liquor shop at Alipur, a secret informer met him and informed him that the accused persons wanted in the present case were present in the bushes behind Khampur so-and-so. At this time, PW 9 was supposedly, then my lord may see, Kanhai Mishra has been taken note of, and that portion has been quoted. Then at para 43, but the secret information could not have proceeded to arrest so-and-so. So this has also been taken note of to doubt the arrests. And with great respect to the learned trial court, my lords, they record that this will be adjudicated in trial, but that has not happened. This judgment may also apply so far as doubtful recoveries, motive, no motive, all these. I'll come back to this judgment again. There is one more Delhi High Court judgment. If my lord wants, I'll give division bench judgment. Also taking note of this fact, this Kanhai Mishra, para 11. That is 2009 SCC Online Delhi 1774. Paragraph 11, my lords. May I just place it?
Yes.
Another example is that when the defense counsel argued that in the absence of disclosing the secret informant, the circumstance of interception of the appellants at Dhansu bus stand on so-and-so, and the consequent alleged recovery of the scooter bearing so-and-so cannot be considered against the appellants, the learned additional session judge felt that this argument had no force because according to him, it was not necessary to disclose who supplied the secret information. The court observed that the fact that the man who gave the information has not been disclosed or examined as a prosecution witness will not affect the prosecution case. The law with regard to secret information being used as a circumstance is entirely different. As indicated in Kanhai Mishra versus so-and-so, secret information alleged to have been received by an investigating officer without disclosing its source cannot be made the basis to prove a circumstance. In Bhugdomal, Gangaram and others versus so-and-so, 1983 Criminal Law Journal 1276, the Supreme Court with regard to information which the prosecution had received observed as under. But since the informant has not been examined as a witness, the evidence of PW 12 that he was informed that accused numbers 3 and 4 would be coming behind the truck in a taxi is not admissible. Furthermore, the fact that the secret informer has not been produced before court also creates doubts about recovery of so-and-so as indicated in the process. Now, my lords, there are further grave contradictions which I will show, my lords. Now, I just showed, my lords, the contradiction between PW 21, PW 5, and so far as the windshield, the IO, my lords, PW 25. Now, my lord, may kindly see the evidence of PW 4 also I showed, who was the helper of the bus. Now, my lord has to consider PW 4 along with PW 13, which is at page 131 of the paper book.
The driver of the bus.
The conductor of the bus.
Yes.
PW 13, just one paragraph, my lords. I'll just place it. On 39/2000, I was working as the conductor in a bus, namely escort, and the said bus was plying from Bhanjanagar to Daringbadi, and the owner of the bus is Baya Naik of village Eklapur. Next line, my lords, is very important. I have never seen the accused person standing in the dock traveling in my said bus at any point of time. I have not seen any dead body on the road near Ek Number Ghati on 39/2000. I was examined by the police during investigation. Here also it suffers from that same vice, not declared as hostile. Now that judgment, my lords, is reported in 2005 SCC, page, my lords, 272, paragraph 9. We'll just give copies. Since it's coming, this point could be raised in this, my lord, I'm just giving it.
So the case of the prosecution is that these accused boarded that bus.
Yes, my lord.
And got down. And
They, after the incident, they boarded the bus and went. That's one part of their case. But they themselves have left these gaping holes in their case.
So this bus helper and conductor are examined in order to show that after the incident, they boarded the bus.
Yes, my lord. But they have not been declared hostile.
You mean the bus slowed down near the dead bodies?
No.
Ah.
It's a post-occurrence event.
That's right. No. So if the helper and the conductor noticed the dead bodies, they must have told the police that we noticed the dead bodies.
My lord.
So when did they notice the dead bodies? That after these people boarded the bus or before?
That is not clear. That is not clear. Now, this judgment, it's a short judgment, 2005 5 SCC, page 272.
You highlighted the portion.
My lords, paragraph 9. I'm sorry, my lords, I have highlighted it
No,
for convenience. but the testimony of PW8 Dr. Sukhdev Singh, who's another neighbor, cannot be easily be surmounted by the prosecution. He has testified in very clear terms that he saw PW5 making the deceased believe that unless she puts the blame on the appellant as his parents, she would have to face the consequences like prosecution proceedings. Did not occur to the public prosecutor. This line is important, my lords. It did not occur to the public prosecutor in the trial court to seek permission of the court to heard, seen as in case, declare PW8 as a hostile witness for reasons only known to him. Now, as it is, the evidence of PW8 is binding on the prosecution. Absolutely no reason, much less any good reason, has been stated by the division bench of the High Court as to how PW8's testimony can be sidelined. So this would apply for PW4 as well as PW13. 4 because he declined to identify the accused in the dog, and PW13 because he has completely given a different view vis-a-vis his own helper.
No, even he says he's never seen the accused who's standing the dog.
My lords. Now, one more important facet which my lords, I have found out, my lords also, and the Supreme Court judgments, is that no blood in the weapons of offenses. So I'll straight away take my lords to that portion, which is at page 207 of the paper.
But what about the clothes of the accused? Because there's some recovery of clothes of the accused.
Recovery of the clothes is also there. Most clothes, they don't have blood. And even if the blood is there, the mapping has not been done. So blood group is not there. So there, my lord knows those a long line of judgments that unless you match it with the deceased, you cannot connect. But my lords may see, so far as the weapons of offenses, that is something which is peculiar. No blood was found. And these are all recoveries made immediately thereafter. One, the knife was there lying on the spot.
Yes.
Now, if my lords would see that from the paper book, Exhibit 39 is the SFL report. It's at page 206.
Yes.
And the relevant portions would be at page 207, entry number 6 and 9. So, if my lords would allow me to show that knife, the mark given to that material object is capital D, and under the next item entry is no blood.
Sword also no blood.
Sword also no blood. And if my lord would see the wearing apparels, most of them show no blood or few small drops of blood. But so far as grouping is concerned, there is no group. Whereas the deceased blood group is B and O. That's entry 22 and below. 22 onwards. Human blood, B and O is there so far as the disease is concerned, 2 deceased persons. But so far as others wearing apparels, no blood group has been found. So what would be crucial is the weapon of offenses having no blood.
Are there recovery witnesses?
Yes, recovery witnesses, my lord, some of them have turned hostile.
No. In any of the remaining witnesses?
Yes, but there is one witness which they may, which may go against my clients. That I'll also show. Now, my lords may see. May I just quickly run through the evidence of the IO, relevant portions, 168, my lords, page 168. I had placed up to paragraph 3. Then from there onwards, I'll just place only the relevant portions. Now, what would be relevant would be recovery of the sword was from an open place, which was accessible to all. That is at page 174 towards the bottom. Paragraph 9. Sword was recovered front side house of Uma Ojha and gave recovery of one country-made revolver and one sword, which he had kept under a tolari, an article made of bamboo and kendu leaf.
What's the significance of this revolver?
That was also given, like...
No. None of the deceased was killed with a gunshot. Okay?
No.
So the revolver has no meaning.
No. The entire other aspects would be, my lords, that vehicle in the PW.
No. Are there any seizure witnesses?
Yes, my lords. Now, one more aspect, my lords, may kindly see. I'll just quickly go to that. That is at page 182. PW 21 in her deposition says that there were 6 people going in that Maruti van.
Correct.
There's a mismatch as to the gender, like how many men, how many women. I'm not going into that. But what is crucial is that none of the others have been put up as prosecution witnesses. And so much of commotion is there. The evidence is that they were dozing off. So all these things, my lords, may kindly see that portion I'll just read. At page 182, paragraph 19. Towards the bottom, out of the said passengers as mentioned by me, witnesses T. Maheshwari Reddy, she is PW 21, and Mamta Kumari Panda. And Bobby are ladies and others are gents. I did not ascertain regarding the position of sitting of the said passengers inside the said van. I examined the passengers of the said Maruti van and except T. Maheshwari Reddy, PW 21, and the driver of the Maruti van, Dudyojan Bisoi, others have denied their knowledge regarding the occurrence as they were dozing at the time of occurrence. And the para 20, of course, I showed, my lords, regarding no mark of violence in the damaged windshield of Maruti van. Now, so far as the face of the accused person is not being covered, that is at page 183, just above paragraph 21. That one line, if I may place only that line, the face of the accused persons were not covered when they were sent to JMFC Soroda. This, my lords, my humble submission is that this may affect the TI parade.
Right.
Then, so far as the recovery of the gold ring, the relevant portion would be para 21, last portion, which is at page 184. May I place from page 184?
Yes.
I had handed over, this is, my lords, very important. I had handed over the seized gold ring to the OIC of Soroda police station on 16/9/2000, and from the time of seizure till 16/9/2000, it was with me. I have not sealed the ring seized by me after its seizure. It is not a fact that neither accused Pradeep, while he was in police custody, gave disclosure statement regarding the place of concealment of the gold ring, nor I recovered the same gold ring in the consequence of such information. I cannot say which police, this line is very important, I cannot say which police officer produced the seized gold ring before the JMFC Suroda on the date of TI parade of the seized gold ring. Now, this has to be read in conjunction with para 18 of the evidence of PW 7, where he says that the gold ring was given, it wasn't seized, it was just kept in a packet. So that portion, I'll just quickly read it. page 116, PW7, the magistrate who conducted the TI parade. Para 18, first line. The suspected ring was kept in a paper cover without being sealed. And if I have to go to the niceties of this seizure and recovery, that is vis-a-vis only one accused. If my lord accepts this seizure and goes ahead, then that will not incriminate the other three. Only Pradeep, that too, so far as the offense of theft of that. There was no blood also on the thing. Now, my lords may kindly see the other materials which have not been spelled out, but they may be materials against my clients, would be their presence one day after in a hotel post occurrence where one person had seen them in muddy clothes. PW 16. So these kind of evidences are there. But if my lord disbelieves PW 21, then it boils down to circumstantial evidence. And then my humble submission would be that the chain is not complete. In view of these PW 4, 5, 13, the prosecution cannot go ahead with this kind of evidence.
This gold ring belongs to one of the deceased.
My lord. That is the son of the informant.
That is Krishna Rao.
Krishna Rao.
And it's seized from A1, Sudhir Oja.
No, she's from Pradeep Mahant.
I see. Then what is seized from Sudhir Oja, Jairam Behra, Santosh Pradhan?
Sword.
Clothes of the
The
deceased.
sword is seized from Sujit Oja, and
Sudhir.
Pradeep Mohanty tells that the gold ring is in a particular person's house. So the statement is given under section 27, and thereafter the gold ring is.
What about Jairam Behra and Santosh Pradhan? What is seized from them?
As Jairam Behra and Santosh Pradhan, there's blood on their apparel that is also recovered.
No, but what leads the police to arrest these people? Only secret information.
And Millers, they were all identified by PW 21.
No, that comes later.
No.
In fact, she does not even know the names. She simply
doesn't.
says that I can identify this. How did the police reach these four? Because she doesn't name them.
Please.
There's no photograph she's carrying. She's just a passenger. So there's no way her description would have helped them arrest these four. How did the police reach them? You do one thing, you examine it.
Please, Millers.
I regarding each of these points, I have judgments. This open place, her conduct, all that. If my lord wants, I'll.
All right.
We have
We'll continue next Thursday.
My lords, in that preliminary note, some of the points have been listed out.
All right.
But that because of this digitization, we had given it 2 days earlier.
Achha.
Some new points we have.
All right. Next Thursday.
Please, Millers. Great.
The others, you just have to give dates.
We are all great.
Item number 23, I will pardon my lord on behalf of Mr. D.K. Mishra. He is in the government panel.
Right.
So I humbly pray 4 weeks time may be granted. So
It is the court is informed that Mr. D.K. Mishra was appearing.
My lord, I am appearing for the informant, my lord. And last occasion, last 2 years back, matter was listed. At that time, the same prayer was made.
Oh, I see.
Pardon?
The same prayer.
Same prayer was made. By that time, he was this.
My lordship, but
I am also there for the informant. You also may fix a date.
My senior advocate is engaged.
You also fix a date.
Fix it for 4th August, sir. It is counsel for the appellant in Criminal Appeal 455/2008 states that alternative arrangements have to be made for the appellant. Since Mr. D.K. Mishra is now a government counsel. Counsel for the informant states that such prayer was made even earlier. In the interest of justice, list on 4th August.
May I pray 3rd of August?
4th.
Supplementary list item 24.
Obliged.
Counsel for the appellant is in some difficulty. Restore. 11th August.
Supplementary list item number 25.
Sir, my lord, I want to place. This is a case convicted the appellant for arrest for life, my lord.
The appellant is in custody.
Yes, ma'am. Yes, ma'am. Yes, sir. And I want to place the FIR first. And the substance of the FIR is like this. Respected ISC Sadar Police Station. Sir, I am Ganesh Das, 62 years old, father late Gangadhar Das, village Lochapada, Police Station Sadar, District Ganjam. Today, dated 23/6/2009, writing this report that I have 4 sons. I with my 4 sons and my wife, Urmila Das, remaining in our house at Lochapada. Out of my 4 sons, first son is Udishthira Das, second son is Akshay Kumar Das, the third son is Bhimo Das, that is the appellant, and the fourth son is Rajsekhar Das. The third son, Bhimo Das, aged 23 years without getting any income, engaged in antisocial activities. And the younger son, Rajsekhar Das, the deceased, fell in second year of +2 science. I, by doing astrology work, support my family. My third son, Bhimo Das, comes to house without doing any work, threatens me to make me separate quickly and give my share money. Otherwise, I will finish you all by cutting one by one. Yesterday, at 11 hours, 11:30, 11 hours 30 minutes, Bhimo, after roaming outside, came to house, threatened me as before. Suddenly, by saying, "Sir," in not audible, "I kill you." Magya thrust me and pushed me. Therefore, my younger son raised me and stopped him. By this time, Bhimo Das leaving me all of a sudden by making out one barber razor which he had saved Rajsekhar on his chest, right shoulder, and face brutally, for which much blood flowed. By viewing this incident, I shouted loudly, for which my 2 sons and mother, my wife, Urmila Das, and neighbors gathered, and Bhimo ran away outside. The condition of my injured son deteriorating slowly. Therefore, by viewing this, to save the life of Rajsekhar, both I and my wife taken to hospital, where the doctor said, after examination, my youngest son, Rajsekhar, is dead. So I reach to you and humbly says, with a hope to investigate the murder of my youngest son and to take steps against the murderer and give justice. Yours faithfully, signature Ganesh Das, the father of the deceased as well as the accused man. And however, now P2 is the informant. It is a separate improvement one. He says again a separate thing. Deposition, my lord. I am the informant. Accused is my son. The deceased is my younger son.
So the accused is the elder brother of the deceased?
Yes, madam. Yes, sir. I am the informant. The page 35. I am reading the deposition of the P2, the informant, the father of the deceased as well as the accused. I am the informant. Accused is my son. The deceased is my son, younger son. The occurrence took place on 22/6/2009 at about midnight, the accused in state of intoxication came to me holding an axe and asked me to give him money. He asked for ₹5,000. I had no money with me except ₹20. I paid him the amount. He insisted that I should pay him ₹5,000. When I told him that I would raise money in the morning, he did not pay any heed. He raised the axe. At that time, the disease intervened and would take the axe from his hand. The accused was very much angry. Out of fear, myself and the disease ran from this spot in different directions, which is a contradictory, and by making improvement to suit the prosecution, they have to change the story. FIR says something and the deposition says something. Thereafter, Pratap Behera came to the temple to tell me to go to my house. On my return, I found the disease lying dead in the body side with stab injury on his chest, neck, and left arm. From my wife, I came to know that after my departure, the accused attacked the disease and killed him. As no vehicle could be arranged, I called my son to stay at Mouda to come with his bike. At about 4 a.m., the disease was taken to hospital on that bike. In the hospital, he was declared dead. The hospital informed the police. When the police came to the hospital, I lodged a report written by myself. Exhibit 1 is the report. 3 is the report. The police held inquest. Thereafter, there was a postmortem. Exhibit 4 is the inquest report. Exhibit 4/1 is my signature. I was interrogated by police. This is a separate story. The FIR says something else. So also another story by the wife Urmila Das, P33. The accused and the deceased both are my sons. Deceased Rajsekhar was aged about 18. Conference took place in the last Asada. My husband and the accused were not present in the house. Myself and the deceased were going to sleep. At that time, the accused came and gave 3 kicks to me. When the deceased protested me as to why he assaulted the mother and father, the accused chased him. The deceased picked up one axe, which was kept by the accused inside the house, and went outside to throw the axe. The accused chased him towards the body side. Then I followed them. In the body side, near our latrine, the deceased was found lying on the floor, and the accused was repeatedly telling, "Pillow utho, pillow utho." And she volunteers, we all the family members used to call the deceased pillow. When I asked the accused as to what he did with the deceased, the accused remained silent. All the another improvements have been made by the P33, the mother of the deceased, and mother of the accused also.
What is your case, sir? Why should we disbelieve the father, mother, brother? Why should we disbelieve all of them?
Lasin.
Sorry? What is your case? Why should we disbelieve the father, the mother, the brother? They've all spoken against the accused.
Yes.
Why should we disbelieve them?
My lord, the confessional statement under by the leading to discovery is made when he is.
Sir, where is discovery important, sir? Eyewitnesses are here.
Eyewitness, that is the kindly seen, my lord. The para 6 of the judgment, there is no eyewitness to the occurrence, Your Honor.
Sir, the father says how they ran away when this man came to attack them with the axe. The deceased intervened, took away the axe. The next thing we know is the deceased is found dying dead.
That the same.
And this pilla utha means what?
That is,
you are there. You are very much there. The accused is there next to the body, telling the deceased, "You better get up."
PW2 by your when lost the FIR by your honor, by your sir, then he told that he is
Anyway, why should we disbelieve these witnesses? It's very clear that it is the accused who killed the deceased.
Your sir, metal witnesses are not have been examined. All total 8 witnesses have been examined.
More than enough, sir. These witnesses are clearly pointing out to the guilt of the accused.
No. How can you conduct?
You have to say why. Otherwise, we are only going to hold that we believe all of them. You're not arguing at all. You're simply saying they are not to be believed. You're not examining, you're not explaining why they should not be believed.
Your Honor, sir, when he shouted, the father shouted, in the affair he stated that he shouted all the wife.
So who killed the deceased? According to who killed the deceased?
Who killed the deceased? That is unknown. This is a barber razor. And they told that by help of knife, he has again they have changed his statements.
Anyway, all right. Anything else?
Actual witnesses P. Mohan Patra and Antaram Behra are not examined. She to be witness to the seizure also. They are witness to the seizure. All of witness to the seizure, P. Mohan Patra and Antaram Behra are not examined. When the knife is seized, first the PW2, the father of the deceased, says that by help of barber razor, the accused attacked. Now he changed the statement when the police seized the knife, he changed the statement. And came to that by help of knife, he has stabbed him. Nobody has seen the occurrence. They have, PW2 has categorically stated, we have later on I came. And PW3 also says the same. I have not seen.
So why would your own parents speak against you? What is their motive to speak against you? What is the motive of their brother to speak against you?
Because I am not doing any work, and
so they are all got together and say, let us throw him into jail.
Yes,
I see. All right. We'll accuse him falsely of killing our own son. One son has killed another son. Parents will go to the police and say this.
Weapon of offense is the backyard of the house, which is an open place, accessible to all.
So parents will go to the police against their own son.
All of a sudden, I humbly submit, all of a sudden there is a quarrel. According to them.
How many injuries, sir? How many injuries in the body? Injuries. Is it sudden quarrel or what?
Sudden 5 injuries. Small 1 cm, the vital injury.
On the heart, punctured heart.
1 cm.
Punctured heart, sir. Apart from other contusions, lacerations. Anything else? Anything?
Once, I'm saying. One lacerated injury, multiple abrasion, so three got laceration, and 5 is punctured lacerated wound, oval shape. Size is 1 cm, 75.75. 1 cm, sir.
You know where it is?
Page 33.
Where it is, sir? Which part of the body?
Just below the left chest cavity, deep 1 cm.
Where?
Cavity,
chest cavity.
Chest.
You know that what will happen in the chest cavity if there's a punctured wound?
If it's
most vital part of the body, sir.
That is true, but out of
glad you agree on that.
Well, nobody is witness to the occurrence. Who killed? How killed? How can anyone will say? Sometimes it is razor.
All right.
As per the FIR. And thereafter later on they have changed their views, the statement. Thereafter when they come to court, they utter that they out of by the help of the knife, he has injured the disease.
All right. Right.
Mr. My pleasure. Only I'm bringing your lordship's attention to page 50.
Okay.
That's the forwarding report. I'm going to the chemical agency report. There must exhibit D on being produced by accused. Exhibit E and exhibit F all are being produced by accused. Then exhibit G, one seized by SK Vaisaki, who is PW7. That means that is a napkin seized from the position of the deceased. And you'll also will come to page 52 with one knife and one shirt, then napkin. These are all all these items have been seized from the accused of the same group A, and that matches with the napkin that has been seized from the deceased. That is also A. That is chemical examination report matches. And PW23 were the parents. It's a case of fratricide. You also has already.
Orders reserved. You file a written note of arguments. All right. Both parties are permitted to file a written note of arguments.
By next week, I will file.